Pledge to our flag. Pledge allegiance
To the flag of the United States of America and to the republic for which it stands, one nation, under God, indivisible, with liberty and justice for all.
At this point, I ask you to please silence all cell phones or other devices. And also let the audience know that there may be audio or video recorded by third parties during this public meeting. At this point of the Sunoco Logistics Mariner East 2 update, Mr. David Rubin.
Thank you, Mr. Chairman. My report, fortunately, I think is pretty brief tonight. For those that were not here at the last meeting, I reported that the Public Utility Commission Administrative Law Judge, Elizabeth Barnes, issued an interim emergency order, which is the equivalent of an injunction, which stopped work, if you will, on the JANIC track and installation of valve 344. That was not considered by the full PUC at its August meeting, and we've been told that it will most likely be considered excuse me, at one of its October meetings. The three next meetings of the Public Utility Commission are September 21, October 5, and October 26. And what they do is publish their agenda about 24 hours before the meeting, so you'll see from the agenda whether or not it is on. We've also found the staff at the PUC very helpful. If anyone has a question, they'll answer it. So that's the update there. On the interim emergency relief order, it's still in effect. As to the case itself, as I indicated, it's on a very fast track. We're in discovery, and there's really not much to report. The hearing is in April, but the testimony is written testimony, and that is due in February. The other thing I've been reporting on is the Environmental Hearing Board action. If you recall from the last meeting, the Environmental Hearing Board issued what's called a supersedious, which is another fancy name for an injunction or stop work order. That was negotiated down with the Clean Air Council to a stipulated settlement accepted by both the Department of Environmental Protection and Sunoco. Suffice it to say, they're doing a lot more field work to ensure that when they do go back to work at the particular hydraulic fracking sites, they will not have the experiences that they had before, specifically frack outs into people's wells, the streams, lakes, throughout Commonwealth of Pennsylvania. So hopefully, when they go back to work on particular sites, we won't see that again. The submissions to be able to go back to work are required to be submitted to DEP and the Clean Air Council. Clean Air Council has 14 days to review. DEP has to act in 20. The long and short of it is Sunoco's been slow in getting those reports to the department. The first batch of 14 went in last week, and they're being reviewed as we speak. In the underlying Environmental Hearing Board case, that too is in discovery, and the Clean Air Council, of course, is taking the lead on that. All we do is monitor that case. We're not actively involved in that case, but we do coordinate efforts. And last but not least, it's been discussed here is the zoning case that was brought up by the Delaware River Keeper and Mr. Casey against Sunoco to enforce the zoning here in this township for the Mariner 2 project. As you recall, that was rejected, if you will, by the Court of Common Pleas on what we call preliminary objections, meaning it never really got to any hearing. That went to the Commonwealth Court. It's been combined with the Middletown Township case. It is on a fast track, and the oral argument in that case has been scheduled for October 13 in Philadelphia by the Commonwealth Court en banc, meaning a full court of as many as 12 judges will hear the case, not the usual panel of 3. So that's the update. If anybody has any questions?
Could you announce the potential dates for October for our,
Sure. The PUC dates for October are October 5 and October 26. So those are two regularly scheduled meeting dates, and it's most likely that the full PUC will review Judge Barnes' order and decide whether to approve it or basically disapprove it, if you will. If they affirm or approve her order, then they won't be working on JANI anytime soon on their valve. But if they overturn it, then they'll be free to go back to work. But of course, then take the risk that they lose the case at the end and have to remove the valve. So, that's where it stands.
now we won't know until 24 hours before whether we're on that list?
Yes, the practice of the PUC is to publish the agenda roughly 24 hours before. And the meetings go quickly for those that have attended them in the past. And for all intents and purposes, there's really no public comment during the PUC meetings. It's a very efficiently run meeting. They can get through as many as 30 agenda items in 20 minutes.
So basically, it's just a call for a vote on whether to lift the injunction or not.
Pretty much. There'll be a written decision that'll be prepared by the staff, the legal staff. So they'll be voting on a legal decision that will be released, but all of that sort of goes on behind the scenes.
So for all of us, or those people interested to truck up there and go up there for, if we're on that list, we won't know till the day before. And if we go up there, they're going through a list and they're voting yes or no on lifting it, boom, no discussion, add it there.
Correct.
Okay, just so that everybody's clear, because I was misunderstood in September when we were ready to go. Am I right? I thought it was going to be a long, worthwhile trip. If we went, of course, they said no. So, just to find out that this is what happens. So, all likelihood, though, it will be October 5th or the other October date.
October 26th.
October 26th.
Correct. Now, there was a suggestion at the last meeting, I believe by Ms. Middlebrooks, that people should go to show support. And also let the PUC know that we're watching, meaning the citizens of this township and the citizens of Chester County are watching what the PUC does. I still think there's value in that, but those are decisions you'll have to make.
The difficulty is that simply, if we don't find out till 3 o'clock the day before, then, to get that word, everybody's gonna have to focus on, we have to get it on our website as ASAP, if that's where people want to check.
And Casey's been really, really good about that, and we've, obviously, the flow of communication between Casey and our office has been several times a day. So it'll be on our website as soon as we know, but that might not be more than 24 hours before the meeting.
And will you send me a
Yep, just like I did for the August meeting, as soon, we knew at like 1 o'clock the day before, David, because you made a call.
Right.
Yes.
We posted immediately, I'll email you, get out the word to everybody.
Okay,
But 1 o'clock was pushing it the day before, so.
understood.
It's pretty incredible, isn't it?
Any questions for Mr. Bruman? Yes, Tom, want to come up to me?
Just wanted to clarify one thing. The case is scheduled for Wednesday, October 18th at 9:30 a.m. courtroom number 1.
Thank you.
Yeah.
I spoke to Mark Freed this morning, and that's the day I wrote down. I could have written it down wrong.
I don't know many attorneys that work on Saturdays.
I said today. I spoke to him
No,
today.
the 13th is
Oh, I'm sorry. I get it. Thank you, though, for that correction.
Yeah, you're welcome. The other thing is it possible for the township to place on the website a direct link and/or petition for comments to the proper source of the PUC if the public wants to chime in on upholding this contract.
There's no opportunity for public comment at these hearings.
No, there's no official, but they do receive these comments and they do read them. So just like showing up is helpful, I think them receiving comments, even though they're not official, shows that the community is in support of upholding this contract in some way. So I'm asking if it's possible to put that onto the township's website so that people have a direct link, so that we're not floating all over social media trying to get this done. It's easier if we just go through one source.
I have no idea.
We'll certainly have a discussion, Mr. Casey. I really want to fight through the implications. I understand where you want, what you want. I'm just not sure that's the proper medium. And frankly, I'm going to also defer to the solicitor of the township and talk about it with him or her.
Okay, thank you.
Any other questions for Mr. Bruman? Yes.
Hi, I'm Erin Morelli from Mary Jane Lane, and I'm part of the Goshen United for Public Safety group. So I just have a statement I'd like to read. So by now it should be clear that the residents of West Goshen are extremely concerned about the land, water, and safety of this community. We are requesting the support of all of our supervisors to act in solidarity and not to settle the matter before the PUC. Goshen United for Public Safety is continuing to build power and organize with the residents to protect our schools and community. No settlement before the PUC. This includes compromises with the placement of valve or acceptance of funds in exchange for modifying the original settlement. You all know Sunoco outright lied and manipulated us when the settlement agreement was being negotiated. We know that our families and children, our homes, and this community are worth more than Sunoco can offer. Will you promise not to reach a settlement with Sunoco Logistics and fight for the full enforcement of the settlement agreement?
I have to counsel my clients not to answer that question because A, nothing has been proposed, B, nothing is under discussion, and there's possibilities of something coming to us that provides a safer pipeline. And I wouldn't rule that out. I'm just telling you my professional opinion. But
Safer.
it can't be asked because it's just a sort of rhetorical question. So I'm going to ask my clients not to answer.
Okay. Well, I would like an answer. Will somebody follow up with me then? I have a copy here. I'd like it added to the meeting minutes.
I think, ma'am, one thing, I don't recognize you, and forgive me if you've been here every meeting, but if you were here back in spring of 2015.
Yeah, I was here.
Okay, so that was the
Part of
process.
the Concerned Citizens of West Goshen Township.
Okay, so that was the process that was followed. If you recall, the entire agreement was put out on the web. There was a public meeting to describe it, and your supervisors basically tabled it to get more public comment, even after the public meeting. So there was a public process then, and I can't envision anything short of that now.
Okay. Thank you. I also had another question. So I was speaking with Chris Pielli a couple weeks ago on and inquiring as to why the Board of Supervisors couldn't meet with Jordan Yeager and the Clean Air Council's attorneys to see maybe if there is some way that they can join the case. And I believe Chris had told me that, it's because the township could get sued. And I believe I just wanted to read this from the settlement agreement. And if you could tell me if this is the reasoning, just to make sure I'm clear. So this is on page 7, I believe, of the settlement agreement, back from 2014. And it says, for so long as SPLP offers to provide interstate petroleum and refined petroleum products, pipeline service to the public, including transportation of propane or ethane, West Goshen Township will not contest, dispute, or protest SPLP's service for lack of public utility status in any federal, state, local, or regulatory proceeding, or file any lawsuit, litigation, or action, or join any lawsuit, litigation, or action with respect thereto. So is that what is preventing us from joining the suit with the Clean Air Council and the Delaware River Keepers Network?
Aaron, well, I recall that conversation, that was part of it. Part of the other reason was the assessment from Mr. Bruman, our legal counsel, that they didn't think that the case was going to have a good chance. The other concern was we always have to watch what we do because of this agreement. We're constrained within the parameters of this agreement, and we do want to make sure when we proceed that Sunoco couldn't possibly come back on us any type of breach of contract and a counterclaim. So yes, that is a concern, so we have to be careful. So when we weighed all these options out, that's the consensus of the board. Everybody has different opinions on the board, and some of our opinions have evolved over time as this case has unfolded. But just to make it clear, that's not the only reason. One of the reasons is, quite frankly, and it's not that we wish this to happen, because this ordinance was enacted in good faith. But when the ordinance was enacted, and I was sitting on that side of the table, it was very clear by Kristen Camp. She said that once they get public utility status, which they did not obtain at that time, the ordinance, in her opinion, would be moot. And the courts have seemed to uphold that. We've had a summary judgment here, right here in Chester County. Threw it out. Before any evidence was presented, any case started, they threw it out. So I'd have to say that whether you agree with Mr. Bruman's assessment or not, the facts speak for themselves. The case was not successful. Now it's on appeal, and I wish the best for it personally, but at this time, I'm sticking with all these different factors, and that's why we're proceeding, and that's why we have this consensus here. And I've also said if there's any way possible that we see something happen along the way, and we could change course to give us better leverage, we will. We will.
So would it be worthwhile for you to meet with counsel from another firm? Possibly there's, an idea, or, I'm sorry, I don't mean to offend you, but
No,
possibly,
no,
David, he just rolled his eyes at me.
No. I didn't roll my eyes, and I never will.
Surprised.
But
Okay.
I am, because what I said in the beginning, and I'll repeat it, is that all the law firms working on these cases are coordinating through my efforts.
Okay.
And I did talk to Mr. Freed today, and Alex
I don't know who Mr.
Bomstein
Freed is.
today. He's your lawyer. Mark Freed.
I was talking about Jordan Yeager.
Mark Freed is his law partner handling the case.
Okay.
Mark and I have known each other for 35 years.
Okay.
We talk regularly.
Okay. So even outside
We're also
of that,
coordinating with everyone that has a case at the state level,
Okay.
and providing whatever expertise we can, and vice versa. So yes, we're all coordinating with one another. That's all I wanted to say.
Okay. All right. No, I didn't mean any offense. I was just
No,
thinking
no,
maybe if someone else knew of a loophole or some way around this that, we might possibly want to look into that, take advantage of it.
As I've said, going back to 2015, and I've had plenty of discussions with other lawyers about it, this desperately needs a legislative fix. You ought to be talking to your legislator.
Yeah. Okay, thank you.
Thank you.
Anything else for Mr. Bruman? When he leaves, this will end the Sunoco situation for tonight. Thank you. Reports for the month of August 2017, Captain Greg Stone.
Good evening. For the month of August, calls for service were 2,173. Alarms were 68, 8 of them being valid, 23 reportable accidents, and the officers patrolled 23,975 miles. Our selective traffic enforcement for the month of August occurred on Crispino Lane, Felton Lane, Sylvan Road, North New Street, Pottstown Pike, Warren Road, Airport Road, and Route 100 Spur. The following officers attended training during the month of August: Officer Riley, Officer Boyle, Officer Jason McGee, Lieutenant Carroll, Lieutenant Domidio, Officer Virgilio, Officer Edwards. That's all I have.
Thank you, Ken. Fire Marshal's report. Andrea Testa.
Thank you. For the month of August, there were a total of 33 inspections, 6 commercial use and occupancy, 7 fire blocking, 7 sprinkler, 2 framing, 1 fire alarm, 1 walkthrough, 4 underground fire lines, 1 paint booth, and 3 fire extinguisher placements. There were 6 fire calls for the month, 3 fire alarms, 1 appliance fire, 1 gas leak, and 1 house fire. I attended 4 meetings, 1 complaint, and I gave 2 fire safety programs. Good Fellowship Ambulance had 106 calls for the month, and Westchester Fire Department had 20 calls for the month. Thank you.
Thank you, Andrew. Building officials report, John Besser.
Good evening. For the month of August, there was a total of 124 permits, 1 single-family dwelling, 28 building, 23 electrical, 2 fire protection, 20 HVAC, 13 plumbing, 4 roofing, 7 zoning, 15 use and occupancies, 4 ENS, and 7 road occupancy permits. The estimated cost of construction was $58,709,649.22. The permit fees were $588,316.23. Thank you.
Thank you, John. This time I'd like to announce the appointment of residents to Comprehensive Plan Update Task Force. Bob Carter, Mary Lesota, Maxine Rickner, Bob Scheller, Bob Stratton, Dr. Douglas White.
I'd like to make a motion that we approve those appointees.
Second.
Any questions from the audience? Okay, all in favor? Aye. Ayes have it, thank you. Township managers' announcements, Casey?
Good evening, ladies and gentlemen. My first item, we have an executive session tonight to discuss litigation. The second announcement, our fall movie series starts this weekend with Moana in Community Park at 7:30 p.m. September 16th. September 23rd, we have Finding Dory, all Disney films, of course. September 30th, we have the live-action Beauty and the Beast. And October 7th, Star Wars Rogue One is at 7:30. Bring a blanket, it's going to be cold. That's it. Thank you very much.
Thank you. Township engineers, stormwater announcements, Rick?
Thank you. Our permit application for the 2018 individual MS4 permit for West Goshen Township is complete and will be submitted to DEP tomorrow. The deadline is Saturday. That application is for a new permit to be issued March 18th, 2018.
Thank you. Zoning officer, Bill Webb?
Excuse me, there's a question.
Is there comments on this?
Yes, you can make
Sure,
comments
Tom.
on this.
Some questions regarding the stormwater permit. Why are we not voting on this?
Would you like to have answered? The DEP requirements to send this plan do not require any legislative approvals. The board has allocated funding in the budget to prepare the plans. We've done all the staff work and consulting engineering to get it done. It's planned. There's nothing set in stone. The DEP has not approved anything yet. We'll most likely have to update the plan, give the DEP comments for the next 6 or 8 months or a year until we get the permit. And then the next step is to approve the projects with the board. So that's why no vote is required.
Well, the concern that I have is there is a vote required because the MPC requires it. The DEP process is very clear that it does not require a board approval. However, for these projects, these are unfunded, unbudgeted projects, which require, these are taxpayer dollars, which require board approval to go forward. Now, I've tried since March to understand why we're not being told, and people that have been through training for this have not been forthcoming with this information. The training is clear. We've had this information since 2015. They've tweaked it. They had comment periods where municipalities and engineering firms who specialize in stormwater all chimed in, including Ms. Ladovic from HRG, who wrote our report. Now, the requirements for this report are very simple. We had to advertise it. We had to present the plan at a public meeting. We had to allow for and answer all public comment. We have failed to do that. We cannot submit this report because it is insufficient. And if we do, it will come back and it will cost us to make these changes. We've already invested somewhere in the neighborhood of $58,000 when we could have simply just changed the $42,000 one that was from 2015 and 16. So my concern is we are committing to something because the rules are very clear, and I'm hoping the board understands this. When you send this application in, you are committing the township taxpayer dollars to pay for this. It must be ready to go the day it's submitted, because they could approve it on Monday. This is not something that is down the road or we'll wait to see what they tell us. You tell them what it is you're supposed to do or what it is you want to do the two things that are required. And now at the meeting in July, it was made clear that we are using the presumptive approach. And what that means is by reducing our sediment by 10%, we presume that we're reducing our nutrients by 5%. If we don't meet that, there's no penalty for that. But the presumptive approach allows for a variance. The other concern that I have is we parsed out properties from the preliminary report, meaning if, just for the sake of argument, we have 10 million pounds of sediment that we need to remove. We are given the ability to parse out, maybe say, for the sake of argument, with all these private stormwater basins, in the neighborhood of 8 million. That lessens our burden to 2 million, just for the sake of argument. So this report, we were presented with a general overview. The report did not give us the plans. When I asked about those plans, I was told that for the sake of that exercise, it wasn't necessary. It was absolutely necessary. I made that clear in my statements when I sent them to the township. My comments have yet to be addressed in this final version. That is a requirement. They must be addressed. Doesn't mean they have to be adhered to. It just simply means they need to be addressed. Some of the parsed out projects, we have projects on here where only 2 of them out of the 7 are township. The other 5 are private. Now, I've asked several times over the months, have we reached out to the stakeholders? And the answer has always been no. We cannot submit this application for this permit unless we have institutional agreements. Do we have them?
There are no institutional agreements required at this point with private property owners.
That's in the requirements.
No, it's not.
Institutional arrangements must be in place for the submission.
No, they don't.
It's the training. See, this is what I'm confused. Have I?
Did you attend
No,
the
actually, Mr. Craig, I'll have to be honest with you. After all my conversations with Ms. Fields, she's telling me that I am 100% accurate in my assessments. And what she's confused about is why we're being told something that is completely different than what is in the training.
I attended the training and that's not.
Yes, you
correct.
did, twice.
4 times, actually.
Last year, June and September.
And in 2015, twice as well.
Correct. So, why are we submitting a plan and the board is going to allow the submission of an application that puts taxpayers on the hook without approving the expenditure? It's not budgeted yet. If we submit this plan tomorrow, you must be prepared to implement it tomorrow.
That's not
Which-
correct.
Absolutely correct.
No,
See,
it's not. March 18th, 2018, if the permit is issued on that date, and if it is not, then upon issuance of the permit, you're required to implement it.
I'm going to invite anyone from the Board of Supervisors who wants to know, contact Ms. Fields tomorrow. She is willing to speak to each and every one of you. I am not mistaken. If we submit this, not only are we putting the board on the hook for taxpayer money without a vote, but we're also allowing for potential malfeasance here. And that's a concern as a taxpayer, because when we go back in time to last year, when this grant was approved for the Basin Road project, there was a statement made that I had some confusion about. And it put taxpayers on the hook for $450,000. And it was, where did that approval come from? And the statement was kind of sort of verbally. I'd like to have clarification on what that means. Kind of sort of verbally in 2015 when we applied for a grant. Now, the board and the township says they applied for the grant, okay? If we used and allowed for someone else for unbudgeted money when the grant said we had it in the budget, to take taxpayer money and guarantee that we were going to put it someplace without the board's knowledge, is that okay with everyone? It's not with me. Management shouldn't have that kind of power. That's your responsibility because it's taxpayer money. So I'd like an answer. Can you please explain what kind of sort of verbally means?
I remember answering.
Mr. Lalonde said that when he made his manager's announcement
2015.
in May of 2016 at the board meeting announcing the awarding of the grant. $450,000 of taxpayer money was committed without board approval. That is a major concern for me.
Why?
Mr. Casey, the board moved $2 million to capital reserve, reserving $500,000 for stormwater projects. That was the match. That was done during the budget process. It was discussed
When?
for 2016,
When was it discussed?
during the budget process of 2015 into 16.
Which meeting?
Our budget meetings.
When was the grant applied for?
I don't recall. I'm not going to sit here and be irritated.
July.
Mr. Casey, I'm sorry.
July of 2016, before the budget process. That is the
The
concern.
2015 budget process for 16.
2015, July is when the grant was applied for. Now, here's the concern that I have.
Go ahead.
At the July meeting, when we had that presentation for the non-existent plan that was never presented to us, which is a requirement for this permit, Mr. Lalonde separated out the two meetings for the Basin Road project, and he ended the MS4 project presentation. During that time...
Wait, hold on. Are you
No,
talking about
I'm
the-
not finished. Let me
Are you
finish.
talking about the July 26th meeting we just had less than?
Yes, absolutely.
We did the TMDL presentation, we opened it up for questions, Ms. Stuntebeck was there,
Mhm.
Ms. Lusoto was there. Did we not have question and answer throughout? Mr. Davis was there, Mr. Craig was there.
Absolutely.
People asked questions, I asked, are there any more questions? Correct me if I'm wrong. Everybody in the room who was there.
Right.
Yep.
and we moved on to Basin Road. There were no more questions.
No. You ended the MS4 permit presentation at that moment and then said, we are now going to discuss a separate Basin Road project. Now, the concern that I have,
Okay.
and why I'm talking about the grant money and putting the township on the hook and this malfeasance stuff,
It's pretty rough there, Mr. Casey. We're not-
7 minutes, 18 seconds into the second video for the presentation,
For Basin Road.
AKRF announced that they were the ones who applied for this grant. That's a concern,
On behalf
because
of
the township did. That's
on
not what the
behalf of
man said.
township.
So now I have some major concerns regarding the approval of $450,000 of taxpayer money without board consent for non-budgeted items in 2015. So the concern that I now have is if we present this plan, okay, the Basin Road project was included. Is that because of public comment? In this final
I'm
draft?
sorry, I'm completely mixed up. What do you mean by Basin Road plan?
No, it
The Basin Road project is now in the final draft plan, which it was not in
Go ahead.
the original.
That was a result of staff comment.
Okay. Does it have anything to do with the requirements for the grant?
No.
No.
The
Because
grant
the-
has nothing to do
We
with
just
the
have to get
TMDL.
credit for it, for the TMDL plan. So it all works.
The grant application clearly shows that we will use the Basin Road project for the MS4 permitting requirements.
As we should.
As you should. But, so we're fulfilling the grant requirements, yes? The grant requirement.
Sure.
Okay, so the grant requirement also talks about, we have this money guaranteed in the budget, which it was not in 2015. If AKRF was the ones who came to the township and said, we can get this, but we need a commitment from the board or from the township, and that was never approved by you, and they approved and put this application through, I don't know what is going to come from that. That's a concern as a taxpayer. We are putting out a product that is already deficient before it even gets there, before it even hits the DEP's desk. The board needs to vote. No, it's not my opinion. This is the opinion of
Are
the
you
woman
actually
who
going to say Jennifer
approves.
Fields, who set up stormwater for DEP, are you going to testify right now that you're speaking for Jennifer Fields, who is up here in DEP? Are you gonna do that?
Absolutely. As a matter of fact,
Okay.
Mr. Lalonde, Ms. Fields had offered me a job because I know enough about this stuff. And they're looking for people who are compliance officers. I turned her down because it's not my interest. But I know what I'm talking about here. And what I'm talking about, Mr. Lalonde, is $450,000 that was not approved by the board. And we are now being put on the hook as soon as this thing goes through. Is this okay with the Board of Supervisors?
Anybody want to-
We're absolutely in agreement.
First of all, his logic is incorrect.
Turn your mic up.
Your logic is incorrect. If the $500,000 was apportioned in the prior year, it was funded, okay? Whether the actual approval of that particular project for 450 was designated to come out of that 500, I don't know that. I wasn't part of that. It wasn't part of that supervisor's group. But I do know from having been seated in the audience that the 500,000 was set aside for that kind of a project. It therefore was funded.
Which year?
That's the stormwater, the major basin.
Which year was that, Mr. Purnell?
That was 15.
In 2015, it was
For the
budgeted,
16 budget.
but the budget wasn't set.
If it was allocated originally, it was in there, it was set.
But it was not. That's the point I'm trying to make. There was no money there. There was no money in the budget in 2015 to guarantee.
There was $2 million in the capital budget
It was
that
transferred in
that was
January of
there,
2016.
And $500,000 of that $2 million was set aside for the project.
2016.
I remember that.
Yes, I do too. That's
Well,
after the
then-
fact.
It's not after the fact.
It is after the fact. So my concern here,
The grant was approved when?
the grant was applied for in 15 and approved in
2006.
April of 2016.
It was approved in 16, and you're saying that the $450,000 grant wasn't approved at that point? Is that your contention?
When we applied for the grant, there was no money guaranteed.
We had transferred money.
What was the $500,000 set aside in the budget
It
for
was
the year
part of the $2
before?
million we transferred.
There was no money set aside for stormwater for this purpose in 2015. That's what I'm trying to get at. But I'm also trying to make you guys understand that this application is insufficient. It cannot go through the way it is. It will come back to us insufficient.
Rick, you have a comment with regards to Mr. Casey's?
We are fully complying with the requirements of DEP in submitting this application. If DEP feels that there's anything wrong with the application, they will contact us to correct it prior to issuing the permit. And we are obligated to nothing until the permit is approved.
That was one of my questions, and it was answered to me, Tom, that this submission, this proposal, it's not a lock-in. You know, what I've been hearing from people saying, you submit it, and the next day, you are stuck with it, you have to implement it. That's not how the DEP is working. It's taking a long time. They're understaffed, they're underfunded, and there's always allowance to modify the plan. So I understand your concerns about timing. You're saying that, you know, this thing was submitted as a proposal to get this grant before the money was actually in there. That's your argument. There seems to be some disagreement on that. But, you know, I'm looking at the big picture. This grant's a good thing. We got it. The money is there for it. Now, we're putting the proposal in. There was no malfeasance, because malfeasance has to have an intent to defraud, to steal, to take. This money was put for good use. So, you know, I want to keep a picture on the big scope of the picture that we're going forward here. So my concerns, and some of the people who were talking to me about this, and forgive my ignorance because I'm not up on stormwater, it's new to me, but the proposal is just that, it's a proposal. And we are mandated for the proposal.
Yes.
And if we do not put this proposal in soon, we could face penalties. Now,
No.
you talked about funding.
There are no penalties, Mr. Pielli. None. There are no penalties.
If we don't have, Rick, if we don't have a stormwater plan in,
By Saturday morning.
are there or are there not penalties?
There are.
Okay.
Can you tell us what they are?
That's up to DEP. I don't set the DEP fines.
Okay. As of right now, the DEP has no fines or penalties for this MS4 permitting process.
They don't have it listed in it, but we're required to submit it by Saturday.
Well, at this
We're not in
point,
compliance with our current permit.
They will
We don't
issue a
submit
notice of
them.
violation against us and then fine us at a later date.
Yes.
they will not fine us because that has to be mandated before the application process. They can't go back in time and fine you for something you did previously. That is not allowed.
We missed their statutory deadline of Saturday morning. They will issue us a notice of violation and then fine us later.
Then I would
I'm sorry to
suggest,
disagree with the DEP.
I would suggest that the board file an application that simply says West Goshen and nothing more. Because right now, this will come back to us. This will go back through. And what I don't understand is that we have people who have been through this training. We have hired HRG to do this report. We've had discussions with, DEP officials. We've had presentations that were given. We were not presented with this plan, period. We were not. And there's no guaranteed funding source. That's the other concern that we have. There has to be a guarantee. Because like I said, if this is filed, the day it's filed, it must be ready for implementation the day you file it. Whether it's approved or not is irrelevant. So if we're putting on taxpayer money to commit ourselves to a plan without a vote by the Board of Supervisors, that's a mistake and a violation of the MPC.
There's a distinction there, if I may, because the board has to approve the funding for the plan. That hasn't happened. So that's a vote that the board has to take. So they could have a plan, the plan is proposed, let's say the plan is approved, the plan comes back to the board. We all collectively have to vote for that plan as to fund it. Now, if we don't fund it, doesn't go through, we face whatever repercussions from the DEP. So that's my understanding of the process and what's been told to me. So I think
That's
when you
right.
say.
That's your understanding from what you're being told.
That's correct. I have to rely
That is-
on my experts to an extent unless I see something differently. But the vote has not happened as far as the funding of the plan. And I think there was some confusion out there about that. And people who might hear what you're saying might believe like, hey, look, you're passing this thing through, there's a cost to this. The funding for the plan itself, the implementation of it, we have yet to vote for it. And that's a procedural matter that we can't do until the plan is approved.
By again, I'm sorry to disagree with you, Mr. Pielli. By submitting this plan, we are committing taxpayer money. Yes, because there's a cost involved, isn't there? And that gets me to my second point. We are only required to reduce by 10%. This plan has us reducing by a whole heck of a lot more.
We're
That's-
required, and Mr. Casey,
That's-
you are confusing the pollution reduction plan with the TMDL plan.
I
We
am
have
not.
both requirements.
We have
We have
two
both requirements.
requirements.
The TMDL plan is much more stringent, and not every municipality in Chester County has a TMDL. We have a total maximum daily load reduction and a pollution reduction plan. Two TMDLs and two PRBs. We have four things altogether that we have to reduce.
the MS4 permit is to reduce by 10%, 75% nutrients.
For the
Yes.
first 5 years, in accordance with the PRP, the TMDL requirements cover a 15-year period and are in excess of 50% each reductions over that 15-year period.
Because when I read with the MS4 application, it doesn't call for that, and that's my concern too. We're talking about increasing our output or our reduction by a large percentage when it's only required to be 10%.
No.
Within 15 years,
So-
we have to achieve over 60% removal of phosphorus for the Goose Creek TMDL. If we do 10% in 5 years, we will never make that goal. And the same thing with sediment for the Christina Basin. We're in excess of 50% there in 15 years. Therefore, if we do 10% in 5 years, we're also not going to meet the goal. So we have to do more than 10% to meet the TMDL requirements. The PRP requirements are only 10%. So that's what we're shooting for with the PRPs. The TMDLs have to be more.
Mr. Casey, did you try and contact Mr. Craig ahead of time with this information?
No.
Yes, when I filed my public comments,
And your public comments will be addressed upon submission
When
of
did
the
you file
application.
them and when?
August 25th, to everyone on this board and Mr. Lamont. Twice.
Okay.
Because as a matter, the first time I sent it, I failed to address my exhibits. The second time I sent it, it said ignore the first time.
I don't know why, but I didn't get it.
Obviously, the disagreement that you have with your evaluation of sediment reduction versus Mr. Craig's recommendation with our submission with TMDLs is much farther apart. As Chris said, that we rely on our experts here, and we'll go forward with it. But as I can tell you right now, that if this Board of Supervisors voted right now, 5-0, against what Mr. Craig is submitting on our behalf, we'd still have to submit it.
Furthermore, Mr. Craig and I will be violating our fiduciary responsibility to the township. If we know if we do not submit the plan, we will have a notice of violation from DEP, and we will get a fine of some amount at some point, Mr. Casey. I am not taking that responsibility when I know this plan has to be submitted.
Okay.
Okay?
When this plan comes back, and it will come back,
Yes, it will.
it will
In
come
one
back
form or another.
In one form or
in-
another.
with deficiencies. And we need to reevaluate how we've done this process, because I've asked numerous times over and over again, have we reached out? For instance,
We don't need to do
basins,
that yet.
5 private basins. If those folks decide that they don't want to play and they don't want to be a part of this, the township then has the option for what?
Do we go find 5 others?
So we're going to.
These are private bases.
We have-
Mr. Casey,
Yeah.
if it were me, I'd want the township to pay it and come in and do it.
Absolutely.
If we are told by DEP to do whatever is the equivalent of 5 bases,
Yep.
and I come to your door and say, this is a property that you own, you're to have been maintained since you've owned the property.
And you may not have.
And,
For 30 years.
and for whatever condition it's in,
Yep.
the township is willing to come in here and do the entire project 100% paid
For
for.
the common good.
If they send us to the next basin down the road, then that's what'll happen. The point of the fact, as I've said all along, and Mr. Schwartz and I have had this conversation, until we get the permit back, as Mr. Piley said, until we see those numbers, then we will make the financial
But see,
decision.
there's the problem, because the plan has the numbers in it already. And if you can't,
Required by DEP,
a lot of the.
just along with the regulations for everything else that we have to submit.
A lot of the private basins and the private work already have their own stormwater requirements and are permitting, yes?
No.
No, absolutely not.
So
Oh my gosh.
one of the
no.
basins
No.
is the county basin off of West Town
And
Road.
you're talking about another governmental unit, all these private basins owned by homeowners don't
But
have
that's
any requirements.
But what I'm saying is, the county has
No,
their own
county doesn't
permit.
matter.
The county does have their own permit. The county doesn't need to do anything
What's
with that
that?
basin in its current condition. If they
Okay,
don't want to.
but, so why are we taking township taxpayer dollars for county work? That's a concern. The other concern is, we moved from the stream bank near the county building to across the street from West Town, to a company that already has a PAG03 permit in place until 2020. Are we going to go to them and demand that they comply with us?
What do you mean, demand that they comply? We have no jurisdiction.
We have no jurisdiction to enter private property, exactly.
So we're including private, non-committed in our plan without having the institutional agreement in place. It will come back
It's
to
not
us.
required.
Institutional agreement
It's not
required
required at this time.
You keep saying that, and it's,
That's because it's correct.
Tom, it's almost like the chicken and the egg, because you go knocking on these doors that are private owners, and if you don't have that plan approved, people are gonna be like, what are you talking about? Well, we're thinking of this, we're thinking of that. It could be seen both ways. It was part of the confusion, my learning curve, was when I heard about the private basins, and it was a concern of mine. And I'm like, okay, what does this mean? Does this mean we're taking people's private property? Does this mean we're forcing people to go above and beyond what we already require? Like, the point is whether it's wrong or right, these permits that we require haven't been checked upon. And what we're doing with this plan is we're coming to them and saying, don't worry about it. We'll take care of this for you. We'll do this. I don't know many private owners that are going to turn that down. So I think they feel pretty secure about knocking on the doors and finding at least 5 basins. So it's different. And I understand the perception. Initial perception when I heard this, I'm having images in my mind like, well, what are we doing? We're going to condemn this property? We're going to take it? It's really not like that. It could be a very mutually beneficial situation here with these private basins. That's the truth. It really can. And if someone doesn't want to do it, that's fine. You don't have to, they don't have to do it.
There's
If someone
200
wants
basins,
us to
we'll
come
go
in
Exactly.
and take care of their basin.
part of the requirements for the public was public outreach. That's part of the requirements, and what that means is that we do this, what you're talking about, in advance. Because what if it takes, let me
Maybe you
ask
have
you
a
this.
good point there.
What if it takes a year and a half to figure out, to get to these levels? Then we're down to 3.5 years to meet the requirements. That is why the DEP said, you guys should be talking to all your people in advance to try to get all of this figured out. And that's why I've been asking you every single month, have you reached out to the stakeholders? And every month I get the same response, no, we haven't. And now we're going to go get a plan, put it out, and say, well, the DEP requires us to do this, and you're on. The concern that I have is that we are taking taxpayer money for private use. We are now, to make it fair, we would have to divide that cost up, yes? And to do that, now we charge a fee. That's what's fair.
Well, we haven't talked about the funding yet on that, but my
Well, no,
point to you
actually,
is.
you have,
we
because
can-
it was guaranteed it was coming from the general fund.
It's the general fund, understood, but as far as the fee that you just mentioned, I don't know anything about any fees, and that hasn't come in front of me. So what I want you to keep in mind is to look at it conversely, okay? And your suggestion is that perhaps a reach out should have been done before, and that might be a very valid point. But what I'm hearing from our experts is, let's not cross that bridge and put the cart before the horse until we have the plan approved. Then go to the private folks and say, folks, this is an approved plan. This is what we want. Would you like to participate in this? So I don't think there's any backdoor thing going on here in that particular thing. Okay, so your first impressions might be, oh my gosh, private property, we're coming on there, we're gonna make these people live. It's not really like that. I don't feel that way. I haven't seen anything yet to feel that way. And if I did, we'd have a different conversation right now. But that's my understanding.
So is it your understanding that we submit this application and we are waiting on the DEP to tell us what to do?
The DEP has to approve the
The
application.
DEP is the approval mechanism for the plan.
But
There's no
The answer is
other-
yes.
The answer's yes.
Absolutely. No
So
one
you're
else
waiting
knows
on them
what
to tell you what to do. So what was the
Yeah.
point of the exercise of producing the plan in the first place?
Because that's the process.
That's the process.
We are telling them what we're going to do. That's the process,
We're
not the other way
mandated-
around.
We're mandated
their
to come up with that plan, Tom.
Exactly.
We have
That's
to
the
come up
point.
with the plan. We have to submit the plan. They have to
This-
approve the plan.
This will come back, guaranteed.
I hope you're wrong. If you're wrong, then we did the right thing. If you're right, then we're going to have to make adjustments. There's nothing going on here backhanded.
No way, you're wrong.
Thank you, sir. With regards to,
Wait a minute, when.
Good evening, Margie Swart. Section 1505 of the Second Class Township Code says the Board of Supervisors is to exercise powers. Just says the corporate powers of townships shall be exercised by the board. I'm just curious as to what corporate powers mean.
Wow. Mr. Brion, you're on, if you want to answer.
Well, all the townships are municipalities that are under the second class township code. All the townships are municipalities under the second class township code, so when you say corporate powers, they have the right to raise money in taxation, they have the right to pay bills, they have the right to own land, condemn land, whatever the case may be. So they have abilities under that code, and when they wrote the code, they slid in there the word corporate powers, very similar, they felt, to corporations that have the power to work for the people under them. So they hire people, they can have employees just like corporations do.
Does the board, and I'm speaking directly to the board, how much is the total cost of the projects that are in this plan that's being submitted? No, to the board. Do my elected officials know the cost to implement the plan that staff is submitting to DEP?
No, because we don't have an approved plan back.
So you don't know if it's $500,000 or $5 million?
Right.
Are you talking about the cost of just putting together this plan? Or are you talking about if this plan is approved, what the final cost would be?
Right.
Is that the latter?
To implement the projects that staff is recommending, there's 5, 6, depending on how you count them, projects. Do my elected officials know the cost of implementing the plan that they're submitting?
I do not know. I don't know the exact number.
Don't you think it's a good idea to know whether they're submitting a plan that's $500,000 or $5 million or $25 million?
Until it's approved, then we'll get the number.
Number's $2.4 million.
500,000 of that was grant money,
300,000.
300, and then 500's already been committed. So now we're down to 1.8 million. The private project that Mr. Casey was referring to, stream enhancement on a private property, is $875,000. So, and again, the board, do you think it's fair of administration staff not to reach out to one of our most valuable companies in this township that's been around for 80, 100 years and say, we're developing this plan, and we're aware that this company, along with all the other companies, Schramm and Safety Clean, Eldridge, Dewey Pile, Conway Freight, they have their own stormwater permits. And they're proposing a stream bank enhancement project on one of our most valued companies that they have their own stormwater permit. Does that make sense to you? And how does that work when DEP returns the approved permit to us and we go to the company and say, geez, we'd like you to cooperate with us? What choice does that company have? What choice do they have?
With choice whether to do it themselves or not have it done, or we come in and do it.
I don't, as a
Is that what
taxpayer,
you mean?
why should we be asked to pay for
We're not being
improvements?
asked, we'd be being told.
So then the only way we can do that, if we're not going to impose eminent domain, is to enact a fee. That's the only way we can go on these.
Or general fund. What if the permit comes back, as we've had this discussion a long time. What if the permit comes back and over a period of the 15 years that we don't need to initiate a fee? We can't have the debate until we see the final approval process.
Well, again, you've been promising and promising a fee isn't coming, but in your application.
I've never said that.
In your
And you said that last time. I never said that. I said that's part of being on the table. Until we see the numbers, that's certainly an option for us, a fee. And the reason why I like it, that's what I've said, is because all the nonprofits, all the 8 schools and the universities pay part of the fee instead of 6,400 residences all by themselves. So whatever the program is, and whatever we're told to do, what if the stream bank restoration is not in there? What if they want street sweeping? What if they change it up and Mr. Casey says they reject this plan and it comes back to us a whole different way? Instead of reaching out all these scenarios, until we see what we have to do, then we will take action to do it. I don't know what else to say to you.
Okay, well, I'll move on because I do have a lot here. This is part of the Growing Greener grant application in 2015. Part of the application does say the township will be enacting a stormwater fee in 2017, which will help subsidize stormwater retrofit improvements on private properties. I'll just move on to the next because that is contrary to what.
And the last time we discussed the stormwater fee
was.
was 2 years ago, which was 2015. That's the last time we discussed it.
Okay.
I don't remember.
There's a project in 2015, I believe, a stormwater project for $900,000, $916,000. Why isn't this plan that we already had a design for in the plan that's being submitted to DEP? The same gal that submitted the grant, Growing Greener grant on our behalf, also submitted a grant. Sure. Again, Carroll Engineering, who is our township appointed engineering firm already had engineering plans done on Basin Road in 2011. Why did we contract out with a firm in Philadelphia for $144,000 to do this project? Again, I don't need answers at this point. I just want to throw some things out there.
Well, first of all, let me answer your first question. That is not an approved project. That was an exercise done by the Pennsylvania Environment Council that was 1/3 of the exercise, for potential areas that we could look at making improvements with the cooperation of private property owners. There was no design, there was no plan, it was all theoretical, with some rough cost estimates of what it would cost to implement. And by the way, the property owner in that case was approached, and they declined to do it.
So again, isn't that a good lesson that maybe you should reach out to these private property owners or corporate partners before this plan goes in?
We have a whole lot of times that we have interacted with different agencies and different private property owners and different HOAs. I think we have a pretty good handle by this time on who is receptive to projects and who isn't receptive to projects. We chose projects that we believe the owners are receptive. We are not, however, going to commit to those owners on doing a project until we know the DEP will approve it. In this case, we simply went to that property owner involved because the environmental council said there could be some significant benefit here. So we said, well, we don't think they're going to like it, but we'll approach them. We approached them, they didn't like it, so we didn't go any further. So,
All right, and just a note on the final plan, this existing BMP, it's just highlighted the wrong basin. I think it's just an oversight.
yes, you're correct, it is the wrong basin. And I'm sure it's an oversight because the correct basin is right next to it.
And again, just moving from the plan from 2015, the stream bank enhancement project from county property, public property, over to a private property that has a chain link fence down both sides of the property, that has riparian buffer all the way down. When I walked it the other day, I had to walk probably 50 yards to even get access down to the creek bed.
Oh, I'm sorry.
Again, 2 years ago, there was a stream enhancement project as part of the plan that was on the perimeter of our sewer treatment plant, our land. I don't know why we're not using that. That was in the plan 2 years ago. Again,
Plan submitted 2 years ago covered a 15-year period. That project may well be done, but it may not be done in the first 5 years.
I did go back and look at meeting minutes from July of 2015 because that's when this Growing Greener grant application was submitted. The signature, it was submitted on, I believe, I want to say July 9th. There was a board meeting on July 8th. I came here specifically to compliment and show my regards and respect to Mr. Murphy, because it was soon after the 2015 election. So that was 2 days before this grant was submitted. And I'm just floored that the opportunity was there to get board approval by the board, and it wasn't received. So, and again, with Mr. Casey, I agree. I don't see this application as an application or a request. This is a contract, because if they accept what you have provided in this application, it's now a contract, and you're expected to fulfill it, is my understanding. So I just wish the board would reconsider and at least know whether this plan, if it gets kicked back to us, are we on the hook for $500,000, $5 million, $25 million? I think I sent you a quick email. Do a Google search of Township Board approves MS4 permits, and every other township throughout the Commonwealth, the board approves the MS4 permit. The board knows what is in this plan. And I don't know I've read about malfeasance, misfeasance, and nonfeasance, and it sounds like in this case, all apply. So, thank you.
Just been accused of a crime, so it's like, well, people.
Okay, I promise only 3 clarifying questions. That's it, okay? That's okay with you guys. I appreciate you giving me just a little bit of time there. I had the opportunity, I'm Robin Stonebeck. I had the opportunity to talk with Mr. Craig yesterday. It was very helpful in helping me kind of understand what was going on with respect to the report. And so I just want to, given the conversation that's been had already this evening, where you clarified more information, I just want to make sure I understand specifically the issue related to the $2 million that was transferred. I think the confusion that we have, or I've had, is that $2 million was transferred, and it appeared that it was related to all of the stormwater projects, but it was then understood, or at least I thought I understood, that it was really just specific to the grant piece, because we had a grant, a portion of it is going to the design group, and then there is a portion which is of almost $450,000 that is associated with, I presume, the actual construction and the restoration. So the confusion that I have is that in the meeting on July 26th, when the question was asked of you, Mr. Lalonde, you said that the projects would be funded through general funds. Okay? So even though there hasn't been a formal vote, and we may not know the total amount of the cost, is it already assumed, because it's in the capital reserve, that that $2 million will be applied to these projects?
Not necessarily. The DEP requirements for this plan submission, and correct me if I'm wrong, we have to identify available source of funds. Currently, by the law, the township can use general taxpayer funds or enact a fee, which Westchester Borough has done previously. Those are the 2 current legal means to fund stormwater projects and existing grants that we have in place. We cannot put in the plan. We're going to apply for a Growing Greener grant in a year. Hopefully we'll get it, maybe not, but you can't put that prospective information in there. So currently the 2 ways to fund projects are general fund money, capital reserve money, and a fee. So that's
Okay.
the 2 legal means to pay for things right now.
So I do see in the funding mechanism section, township general funds, available grants, but we already have a grant. So why is that not already identified in here? Should it have been?
Well, the project's identified.
But the money has not been dispersed to us because the project hasn't started?
Okay, we won't be receiving any reimbursement until next year per the grant, per Growing Greener. We haven't received any reimbursements yet.
But it's committed funding?
Yes, absolutely.
Okay. So back to my question about the $2 million. Is that committed funding for these projects?
That's at the board's discretion. I won't speak for you. That's at the board's discretion.
Okay, so the board never agreed that that money would be going to the general, be going to stormwater projects. So then why was $2 million transferred, not just the $500,000?
It was made available, it wasn't dedicated to, it was made available for.
I'm sorry, I don't understand the difference.
Well, the $2 million transfer was made from general fund surplus
Right.
to capital reserve, which we have been depleting over the years, just to bolster the capital reserve fund. That's why the money was moved. We had over $10.5 million in our general fund
Okay.
fund surplus, so they moved $2 million, decided to move $2 million.
So the current balance in the capital fund is somewhere around $3.8 million currently? Does it seem reasonable that that site still, that the money that could have been used for stormwater could still be sitting available for these projects?
That's the board's discretion.
Okay.
Absolutely.
Well, I think my biggest concern is that for the last, I don't know how many board meetings, we've been listening to the fact that we haven't been able to make any decisions or share any information about what's going on with the permit, because we needed to wait to find out what they would say when they receive the permit. Now, having read this report, I would assume that the people that you've hired have prepared a report that is in compliance, as you both have said, with the expectations, the requirements, and will meet the needs because they are experts, correct? Okay, that's why we hired them. So to get the minimum amount of reduction in terms of that 374,000 pounds of sediment, it would cost about 1.878 million, which is a good number because that's under $2 million, and that doesn't even that includes already the 500,000 that was already identified for being part of the grant. If we decide to go, again, these numbers might change because maybe some of the calculations will be a little bit off, but in general terms, my concern is that we've been hearing about this for 2 years. We understand that there has been a program underway. We've been delaying presentation of this data until July, when we finally had a chance to understand what was going to happen. And I wonder why it took this long, because at the end of the day, I was surprised to learn when I had the first presentation that it was private property that was going to need to be retrofitted. So in the time that I believe we had people here who were working in the Public Works Department, the fact that many of you have been Board of Supervisors for quite some time, why was it not thought to be proactive in planning for this permit to already know the sources of your funding, since 5 of the 6 projects are private? If I was a person trying to negotiate or create a relationship with an organization so that I could ask them for them to give me their land so I could then go fix it, so I could be benefiting from it, I would have expected that over the last 2 or 3 years we could have had maybe those conversations started and already geared up and on the runway, so that when we get the permit, we can jump in and actually get the work done. Because to your point, we don't want to wait and have 3 years to finish this project if we have to go back and ask new people to pony up the money or pony up their land for us. And I also want to know, when it comes down to that, so this is my last question, I'm sorry this is going longer. I'd like to understand the process for selecting these basins, because I understand that one of the basins has an owner that is affiliated with our outside counsel. And I just want to be sure that the...
I'm sorry, wait, you can't just say that. And which outside counsel?
Unruh Turner Burke and Freeze.
They work for the sewer authority, for us.
Oh, they're paid by us, for taxpayers. Our sewer bills pay for them.
That's not the.
No, I'm pointing it out.
Okay.
But what I'm saying is that I think in a selection process, there needs to be anonymity, and I think that it needs to be based upon just specifically, the construction needs that we have in the township.
I'm sorry.
Okay.
I'm sorry.
Maybe I misunderstood the process for identifying these basins.
I'm sorry. Are you, I'm sorry.
Please.
Yeah, which basin are we talking about? Let's start
Haggerty
there.
Road, Haggerty Boulevard. The storm restoration, it's not a
That's
basin.
not a basin, it's stream bank.
I know, I understand.
Okay.
But I don't understand what the concern is. We're not taking anybody's property.
I understand that too.
All we're trying to do is improve conditions that are already there. And that property, I believe, is owned by Bill Freeze, not Unruh Turner Burke and Freeze.
I understand.
So.
Mr. Freeze?
Mr. Freeze is an
It's not
attorney.
Mr. Freeze, an attorney.
That's not Mr. Freeze, the attorney. Mr. Freeze owns a bunch of property. He's a business owner. He's not a lawyer.
Okay, then that was my error.
He's
I
not a
don't
lawyer.
appreciate that, okay.
It's not a
And
company.
Unruh's office is in the borough. They don't own property on that.
So, but my point was brought up because of my concern that there was some conflict of interest.
Well,
But
there's no conflict of
I
interest.
understand that.
Mr.
Let me
Freeze-
just
okay.
finish my point. My
Okay.
point is that I'd like to know what that selection process is, and going forward, if it turns out that we have to identify other locations, that it be done in a way that is transparent and open for everyone to understand how they were selected, just to avoid the appearance of conflict. Okay? That was my whole point, based upon an error in my understanding.
Wow.
But I still think it's worthy of being recognized, because I think it's a concern that there may be organizations that will benefit from our need to use their property to retrofit it for our needs as a township, but it's still private property, and they should be held responsible for maintaining their own basins. I thought there were already ordinances in place to enforce that, and I guess we're benefiting from the fact that some of them haven't actually been doing that, so we can use them for this process. I just would like to continue with the transparency on how they're being selected. So thank you. I apologize for being long.
Does anybody else have any comments? Hearing none. Bill?
Thank you. Zoning hearing board we had a hearing on the 23rd. However, first time in my 17-year career, I had a zoning hearing decision appealed, which the Hawes decision has been appealed by Dr. Jester and his attorney, Brian Nagel, to Commonwealth Court, or Commonwealth Police Court. So I guess this board needs to skip this. First time I've ever dealt with this, so I don't know what our next step is. I don't know if they have to do, because we have to just agree to pay for this, because we pay for it.
Well, actually, when the appeal takes place to the Common Pleas Court, the appeal is handled by the township solicitor and not the zoning hearing board solicitor, because the township becomes the appellee. They're appealing a decision that is under the township auspices. So your zoning hearing board solicitor under Turner, Burke and Freeze would not be handling that unless you decide to get another counsel besides your solicitor. So what would happen is they filed an appeal. The courts put together a briefing schedule. The courts would require briefs. Most of the time there's no testimony because it's all done in front of the zoning hearing board. The court reviews the record before the zoning hearing board to make a determination as to whether the zoning hearing board was correct or whether the appellant, I guess Dr. Jester, you're saying is correct. And then that would either be remanded back to the zoning hearing board if they felt additional evidence would have to be taken, or they could overturn the decision of the zoning hearing board and grant whatever relief that they're looking for at that point in time.
Should, because I had the conversation with Mark Thompson today, should we prepare the writ, or should Kristen prepare the writ, or should Mark? Because he said he was going to prepare the writ to send it over to the courts.
Like I said, normally what happens is when a zoning hearing is moved to the courts, the township takes a position on that and handles the hearing. That's really up to the township at times as to who they want to do it. But the zoning solicitor would have to be then representing the township and the zoning hearing board, because the zoning hearing board is appointed by the supervisors, and therefore now you are in the middle of it, so to speak, because it is against the township at this point. It's against the zoning hearing board, but you're appointed board.
Mr. Brett, should the board authorize you to proceed?
Sure, we can file the writ.
I'll let Mr. Thompson know that.
Well, just so the audience is clear, Kristen had talked to me about this case when it was coming forward. The Jesters are adjacent property owners. Just so we know, the zoning hearing board had ruled in favor of the applicant. I think the applicant wanted to build a garage within setback, if I'm not mistaken. Is that correct?
Yeah, within 25 feet.
And then the Jesters were the adjacent property owners, and they came and became parties of interest to oppose that application. So in this instance, the case is being pursued by the adjacent property owner, not wanting the zoning hearing board's decision to be upheld.
And just so the board's aware, the property in question is vacant land. The Jesters own vacant land, and they presented no evidence or defense in the zoning hearing. All they presented was testimony of stormwater issues with no evidence of the stormwater issues, not even a picture.
So if someone from the board will make that motion, you pursue the case. Dr. Rich.
I'll second that.
Good.
All in favor? Aye. Nice, huh?
Very good.
Nothing further.
Thanks.
Table 12.
The approval of Board of Supervisors minutes of August 16, 2017 will be tabled until next month.
Okay, I'd like to, next thing on the agenda, so I'd like to move for approval of the treasurer's report dated August 31st for the general fund, the sewer fund, the waste and recycling fund, and the capital reserve fund, and any bills to be paid therefrom.
Second.
Yes, Mark.
Hi, I'm usually step up here on behalf of myself. I have a request on behalf of my homeowners association. I mentioned this a couple months ago. We've been there 12 units for about 7 years now, and we've never received a fire hydrant bill. And as of June 1st, we are now being charged $109 a month for the 2 fire hydrants on our property, our homeowners association property. Again, I refer to second-class township code, and it gives the townships 3 different options as a way to assess or pay for fire services. And I believe we fall under number 3, which the Board of Supervisors may pay the cost for fire protection out of the general township fund. If the Board of Supervisors elects to pay the cost of fire protection services out of the general fund, any special fire protection districts and annual assessments shall be abolished. Long story. I believe that through our taxes that we pay to the township, that this bill I'm asking to be paid by my board. So
I think you asked us before in the past. We pay fire hydrant fees on public streets, but not on private properties.
that seems to be contrary to the second-class code.
No, the township doesn't pay for fire protection under the second-class township code. You have a volunteer fire company here. That's the difference. It's not a paid-for fire department.
Well, this is actually section 1802 titled Fire Hydrants and Water Supply, to be clear. So may I leave a copy of the law and a copy of my bill and ask that it be paid by the township? I'm just curious too as to why for 7 years we've never had to pay one.
Was that just a,
Do you take it just under advisement? Do you reject or accept her?
We're not paying.
We're not paying for it.
Surprise, surprise.
what's that?
I don't believe we have paid.
But for 7 years we've been there and we've never, why all of a sudden did Aqua come out and shut off our hydrants, and then all of a sudden, they said it's up to the township. They said this is an issue between the township. This is what what do my taxes get me?
Oh, wow.
Well, we don't get snowplow service, we don't get trash service,
You have
we don't get stormwater
You walk
service.
into a private facility
Okay.
with a private.
I'm asking.
We don't pay for.
That was your choice.
Margie,
Where you moved.
the bill from Aqua, or is the bill from the township? I thought you said it was from...
It's from Aqua, and when our treasurer reached out to Aqua,
Right.
Aqua said, you need to contact your township, because it's up to the township whether they're going to pay. I mean, our township pays like $178,000 a year for fire hydrants. So why?
But we do not pay for fire hydrants in private communities.
Exactly.
They must have billed Chris Aqua, and then Aqua turned around and billed the association. Passed it on.
Okay, thank you.
So, okay, thank you.
Okay.
Oh, I'm sorry.
Yeah.
Any more questions?
Okay. You got a first and second? All in favor?
Aye.
Okay, now the Woodlands, the Greystone, project financing discussion.
Good evening, board members and members of the audience. My name is Lou Colagreco, and I represent the Drahian family and the eventual developers of the Greystone property, RLD Development. Bill Reeser cannot be here tonight. He's attending to some issues with his property in Florida. So we wish him well down there, but Bill's partner Drew and his son is here in the front row. The Drahian family is scattered throughout the audience here. Dean is a face and Helm is a face that you recognize from the past. But this project, just so I'll try and be quick here. I know you've had a long night so far, so we'll try and speed it along a little bit here. What we're here to do tonight is to advise the township. We've already met with your staff and put them on notice that this project is probably going to begin, knock on wood, after 10, 12, 13 years. Ray, you probably know better than anybody here. A long time. Dirt will probably start being moved later this fall or later, maybe early winter, or maybe in the early part of next year. But the project has associated with it about $20 million, maybe $21 million in public improvements. And that goes from the Connector Road, which is going to join Pottstown Pike to Phoenixville Pike, which has been on your comprehensive plan for a long, long time with no money to pay for it. But that's going to be part of this project. And the board also, during this approval cycle, successfully managed to acquire, or will acquire, a 165-acre municipal park. So there's a lot of benefits, a lot of people we know have been in the community are looking forward to this, and they're looking forward to it getting started, and we are too. So, Rick, you have this slideshow. Just put up the first slide of the plan. That's just the cover slide. And what we're here to talk to you about tonight, and I'm not going to do much of the presentation. We have two folks much more knowledgeable in this than I am. We have Lindsay Banner from Unicap, who is helping us put together some of the financing issues that you'll hear about tonight. And Ken Luddinger, our bond counsel, who is much more well-versed in what we're going to be proposing to the township this evening. Suffice it to say, and I'll give you the good news, and then I'll let those folks explain to you how all this is going to come to pass. The state of Pennsylvania has enacted a statute which enables more or less the future residents of this community, not the residents now of West Goshen, but the future residents of this community and the developer to go forward and come up with a way of financing the improvements such that the current taxpayers of the township will not be burdened or shouldn't be burdened. And I know that one of the issues we've always had with, really the township has had with Greystone is that, well, we'll have this park, I think it will double your park system, more than double your park system. It is a gorgeous park with, I think, 6 miles of trail, open lakes, a boathouse. Well, it all sounds well and good until now somebody's got to pay for it and pay for the maintenance of it. So hearing that, we're going to take advantage of this program that you're going to hear about tonight, where if things go as proposed, the taxpayers could conceivably, and the township could conceivably, not only end up with a park improved by the developer at developer cost, but the maintenance of the park would also be absorbed not by the taxpayers of the township, but by the future residents of the community. So with that said, that's about all I know about this process. I know a lot about the plan. If there's any questions on the plan or the improvements, we can talk about them, but I don't want to waste time. I think everybody knows by this time what we're proposing at, certainly the board knows, at Greystone. So with that said, I think, Lindsay, why don't you come up here, and Ken, why don't you come up here as well? You guys can do sort of a tag show. We're going to briefly run through this slideshow, because maybe question and answer at the end is the best way to get some of the answers that you folks may have, or maybe the audience may have. Lindsay?
Thanks, Lou. So, as Lou suggested, what we are proposing is what is called a neighborhood improvement district financing that's permissible under state statute. And what this is a self-financing tool for local governments that facilitates the construction of public improvements, such as those that Lou alluded to. It accelerates the installation of needed and desired public infrastructure, such as that proposed for the Woodlands at Greystone. It's accelerating the delivery of those improvements from an estimated 5 to 7 years to a 12 to 18 month period. And then finally, it encourages economic development, such as what would occur with the delivery of the proposed 598 units at the Woodlands at Greystone by increasing the township's tax base. Next slide. So how does Neighborhood Improvement District or NID financing work? Pursuant to the statute, a geographic boundary is set, typically the size of the development, in this case, the woodlands at Greystone, and it allows for the imposition and collection of special assessments solely within that district, not on the general taxpayers, but only within the geographic boundaries of this development. So the special assessments are then imposed on all of the taxable property within the NID. That special assessment, which is used to finance those public improvements up front, is allocated on a proportionate basis to all of the taxable property owners within the NID, and it's paid in addition to the real property taxes that the taxpayers pay. And so up front, it would be the developer because they own the tax parcels within the neighborhood improvement district, and as that project is built out, that would transfer to the taxpayers within, and that would be disclosed to those home buyers as they purchase the property through several forms of disclosure, whether that be the HOA documents or through the lien created on the property with the recordation. And those special assessments are then billed at the same time and in the same manner as township real property taxes, but it can be administered and collected and imposed by what's called the NIDMA, or the Neighborhood Improvement District Management Association. And so the benefit of this special assessment is that it is on a parity lien to your real property tax, so it can be taken to tax sale in the same procedures as real property taxes. Next slide, please. So, as I mentioned, the Neighborhood Improvement District Management Association, or the NIDMA, can collect this special assessment to mitigate any time and efforts needed by the township. It can be transferred to the NIDMA so that it reduces any time committed by the township. And the NIDMA can furthermore hire a third-party administrator to perform all of the tasks required by the NIDMA. So every year, an annual installment of the special assessment would need to be determined to collect on those property owners. If there's any prepayments that would like to be made, they can help collect and calculate that. They can field any questions so that the township doesn't have to bother with the day-to-day tasks associated with those home buyers and homeowners within the NID. And finally, the third-party administrator can complete any monitoring and reporting. And the benefit of the special assessment is that it is levied in the amount of the principal, interest, and any administrative expenses associated with all of those third-party administrative tasks that can be then collected to pledge towards market-issued bonds, which I will then turn over to Ken to talk about what those market-issued bonds would finance.
Thank you. Thank you, Lindsay. The next slide, please. This is just a listing of the various public improvements, and these would all be conveyed to the township. None of this would be private property. Next slide, please. Now, as Lindsay indicated, we would create this district. And to create the district, first we will prepare a report detailing exactly the size, scope of the district. It will include all the improvements that will be funded will be within the NID district itself. Once we're required under the statute to send a copy of the report to the property owners, and then we're also required to have a legal notice of a public hearing. The public hearing is held at least 30 days after the reports are sent to the property owners, and the public has an opportunity to comment on the plan. If the property owners object to it, we're done. We don't go any further. If there are not objections from the property owners, then we'll come to the township for their approval of creating this NID district and imposing assessments. Now, the assessments are simply a cash stream, a flow of money that can be used to support bonds. So we would be issuing, we're proposing to use the Local Industrial Development Authority, the Chester County IDA, to issue bonds that would be secured by and payable from these assessments on the property owners. I'm told that the project is about $21 million. There are various reserve funds and capitalized interest that might increase it, but bonds would be issued, which would be limited obligations of the IDA, if they are in fact the issuer, payable solely from these assessments. If the assessments are not available, then there's no liability on the part of the IDA, and there's no liability on the part of the township as well. Again, it's payable solely from these assessments. There's no pledge of the tax revenue or the faith and credit of West Goshen Township or the county. Because the credit is dependent upon the ability of the property owners to pay it, it's not this investment grade credit. So these are typically sold to large institutional investors, Vanguard, others seeking a high yield. Because they're a weaker credit, they pay a higher return on that investment. So funds like Vanguard buy these to ramp up the return, to support more traditional general obligation bonds issued by townships and the like. Again, in the event of default, because these are limited obligations, the bondholders would only have a claim to the assessments. And if assessments aren't paid, as Lindsay pointed out, they can foreclose on property in the same way they can for failure to pay taxes. The real advantage here, on the next slide, please, is simply that this process allows us to expedite the improvements. In a typical development, public improvements of this scope and magnitude would not be done until they've sold homes and they've developed a property. And whereas in this transaction, as is proposed, we would actually be able to go out, once the TIF district has been created and the assessments have been approved, we would be able to go out to the market, raise the $20-odd million to pay for the cost of the project. The monies would be held in a trust account with a major bank and would be doled out to pay project costs upon submission of requisitions. And at that point, they would be able to build the improvements at the front end of the project rather than the back end. And also because the improvements and the financing could most likely be done on a tax-exempt basis, the cost would be lower, which would allow the developer then to contribute funds to provide a reserve fund for maintenance of the park, as well as to purchase various equipment like needed to maintain it. Yeah.
That was a lot of information. Nick, Rick, can you go back to the slide of the project, and then I'll wrap this up. But I think when I first heard this, I heard what Lindsay and Ken were saying, and I tried to assimilate it down to how is this going to work? Well, you see up there on the slide, most of what you see in green is the township park. Some of it's going to be private open space that goes with the little. Oh, thanks. I'm giving it to the wrong guy.
How do you turn
Okay, so most of this is the the lakes there. That's going to be all part of your public park system. I think, Ray, what is there, 6 miles of trail?
6.8 miles.
About 6.8 miles of trail. In a normal development without this, and there's the connector road. That's the road that goes right there from Pottstown down to Phoenixville Pike. So that's a big road, and that's an expensive road. And then there's a bunch of off-site traffic improvements at some of the area intersections, which are needed now. So there's about $21 million. What's that?
Which are funded.
Yeah, they're funded through the NID. It will be funded through this NID. So the benefit to the township, as I see it, is, and they do this in other states, so I'm told. In Pennsylvania, we have our process typically is that the infrastructure follows the home sales. In fact, in the approval that we got for Greystone, the final plan approval, the park doesn't have to be turned over to the township to the sale of the 200th unit. The connector road doesn't have to be completed until halfway into the job, probably 200, 225 units. That's a long, that could be about 5 years given the absorption rate now. And if we hit another recession, it could be 10 years. But the advantage of this is that the financing for the public improvements comes right in up front. So that park, which may not otherwise be available until 2023, is available in 2019, maybe 2018 if we actually get this thing going, this winter and next spring. All of the intersection improvements in the connector road, same deal. When that might have taken 5, 6, 7 years under the way developers typically finance these projects, now it gets done, what, in 12 months, 16 months, 18 months. So I'm excited about the level of this different way to finance these public improvements other than the traditional way. And we spoke to the township, of course, the first question is, what's the downside? I mean, what's the downside to West Goshen Township? And frankly, the township pays people to figure out what the downside is. They don't have to listen to me. and probably wouldn't listen to me.
But we think you have something to say.
Okay. They'll listen, but they'll take it with a grain of salt, let's put it that way. But I really don't see what the downside to the township is, and one of the things I thought about, those of us who are in the business and who do development work, in the last recession in 2007, jobs like this stopped for about 3 years, 4 years. They stopped. A lot of them went bankrupt, a lot of them went under, a lot of them, and we're still, believe it or not, here 10 years later, still sifting through that. If that happened here, under the traditional development scenario, the connector road gets caught up in that, it doesn't get built, the project stops, it doesn't get done. The park doesn't get done. But under this way of financing the public improvements, should that recession occur 2 years from now, 3 years from now, the connector road's in, the park is dedicated to West Goshen Township, you folks are using it, you're using the lakes, you're using the boathouse. The only thing that's not getting built are the houses. And they'll come back, they'll get built when the next recession comes and goes. So it's an accelerated way of financing public improvements that's not traditional for jobs of this size. So with that said, if there's questions from the board, yeah, go ahead.
My first question is, I think he mentioned that since it's through the CCIDA, Chester County Industrial Development Authority, you expect the proceeds to be tax exempt?
Well, the Internal Revenue Code and the regulations have various rules that dictate when a project can be taxable or tax exempt. This would be issued by the IDA if they agree to do that. I'm meeting with their lawyers tomorrow. But it's due to the nature of the project. We're talking about public improvements, no private property, all of which will be conveyed to the township. So they should qualify for tax exemption on that basis.
Okay, the second question is then when do you expect the roadways and the improvements to be dedicated to the township?
Well, that's a good question. We're working that through now with the township. I mean, or theoretically, when they're done, they can be dedicated. So, but obviously, it's going to be a construction site. So we're going to have to work with the township. You may take dedication of the roads when we're done, say in 12 months or 14 months, with the proviso that we have to come back and do
an overlay.
Yeah, an overlay. Thank you. And then, when the project's done. So while the township would own it, my guess is, well, I know that the township would insist that when the project's done and all the dump trucks and all that are off, that we would come back, put the overlay on, and then we'd probably have to post a maintenance bond for 18 months after that to make sure that everything works the way it was supposed to work. So the staff has thought that through, but my guess would be you probably want to take it, so you probably want to take it as soon as it's done, but that's up to you, that's up to the township.
The benefit would be is the public roads, we would be able to maintain and plow. Up until you take dedication, you can't be plowed, and we have a difficult time with the project this big for having private entities coming in and servicing the roads with snow clearing like we do. But to be clear, to simplify as much as the Board of Supervisors would be asked to create a neighborhood improvement district. And by creating that district, it enables you through this mechanism to do this bond issue. And therefore, all the public improvements would be upfront for the beginning of the project until all the improvements were complete, meaning your estimate of 18 months.
18 months. That's a good summary, right?
Well, as I know Mr. Pielli and myself are going to go and visit communities that have and use this for years and years and years. I do worry about a project that would be so big that if for some reason in a recession it did stop and we're looking at half improvements undedicated, not done. So the advantage to us is as long as there is absolutely no financial obligation to our residents and no backing of that securities for us, then it's a win-win situation. Chris, you were involved.
Yeah, I mean, honestly, when I first heard this presentation, it was what, several weeks ago, my first was like, what's the catch? You know, I mean, it's got to be a catch, right? But
bingo.
Doesn't seem to be one, because we do not have to put the full faith and credit of the township behind this endeavor, other than the fact that we have to create this NID, you know, which sounds like something that we should look into. It's a front load sort of situation. We get the benefits of all the public improvements up front. And as was explained very nicely, thank you, one of the concerns people had, and we brought it up, well, what happens if, you know, a recession comes and things go belly up and we're just left with this undeveloped land? Well, that's not what's happening here. What's happening here is that, you know, that has to happen first, and it will have funding, and it will be completed. And if there's anything that's not going to be done, it's going to be more housing. So in a way, that's something that's not so bad either, I guess, depending on who you speak to. So it seems like a win-win situation.
I think that there was an example of a property, I don't know whether it's the one we're going to look at it, but they did do this, and they did have problems with development, and so what sat there was just trees and unbuilt homes, and all the streets were in, all the stormwater facilities were in, everything was there and done, and so start building your houses when you do, otherwise streets are finished, the roads can be maintained, and it's pretty ingenious to me.
It's interesting because, Ray, you know, look, I'm learning this too, because in Pennsylvania, we're not used to doing this, and mostly it's been done on commercial projects, according to Ken and Lindsay, you know, where the overhead nut is a big one. And the overhead nut on this one's a big one. The $21 million is just for the public improvements. The private site improvements, what, do you have any estimate what that would be, Ray? Maybe another $50 million. That's not part of this. This is only for the stuff that goes to the township, or the traffic signals and all of that. So yeah, this is an expensive project. And essentially what it means, the long and the short of it is, nobody sitting in this audience, if you live in West Goshen, you won't be paying this assessment unless you move to Greystone.
Those folks back there were voting.
So, good, it's good.
Well, the other thing is too, that affects everybody immediately, not just the boulevard being done, but all of the major improvements on the intersections. I mean, we are in a traffic volume situation as this township has grown, and rather than taking 5 years to 8 years to finish those intersections, there'll be a big improvement to this township finishing them in a year and a half.
What's unique about this is that it hasn't really been done for residential projects other than on a limited basis in Pennsylvania. We've used the NIDS before for major transportation projects. In one project in Lehigh County, for example, a big warehouse distribution center was being built, but the Interstate 78 the overpass and access roads from Interstate 78 were not adequate to support the development. So we were able to use the Neighborhood Improvement District, which was approved by the township, Weisenberg Township in that case, in Lehigh County, to fund an overpass over Interstate 78. Another case in Northampton County, they funded an overpass over Route 33, again to stimulate development of industrial development projects, to create jobs and create business. Here we're proposing to use it for a residential project. And we just wanted to introduce the concept to you tonight, and we will be back. Again, the statute specifies a procedure that needs to be employed to complete this. And the first step is completing a report, which will then be distributed to the public, be public hearing, and it's only after the public hearing and after the public has had an opportunity to comment and object that we'll be coming to you to authorize it.
If you could just for a second, for the crowd, to enunciate the savings and the endowment aspect of it, because I think that's a pretty attractive thing. Once again, normally any cost associated to this development or inspection or oversight or whatever, that's cost to all of us as residents. But under this program, that cost is going to be alleviated. And then additionally, there's the endowment.
Yeah, the endowment, Chris, I think that you're speaking about, the Reeser Land Development has offered, in addition to the NID, there'll be $1 million set aside for sort of seed money for the township, an endowment to, because for a park like this, you have to buy vehicles, I guess. There's probably going to be some personnel issues that the township has to make. But even the cost of that can be rolled into the NID as well. So I know the nut that the township was wrestling with when we went through the Greystone approvals for the last 10 years was, okay, we're going to get this park, but someday, and that someday's now, someday we're going to have to figure out how to pay for the ongoing maintenance of the park. Right now, I guess you have a park budget. I guess you have a budget that you use for your other parks. So you have a pretty good handle on what might be required. This could be funded through this $1 million endowment, plus through the NID financing. So what it means here is really the folks who are going to be paying for all this aren't, unless you move into this subdivision, unless you are the property owner right now, or the developer right now. Maybe, I don't know what the additional, and when we come in with the report, we'll be able to gauge about what the assessment on those homeowners would be to finance this. It'll probably be a 30-year assessment, that's what we're looking at. And they'll have two assessments, really. If you buy into Greystone, you'll have your HOA fees, because there's always be common amenities that are private, so there'll be some dollar amount set aside for that. And then they're going to have this fee, that the developer thinks that this site is beautiful enough and that these lots are going to be attractive enough that that won't be a hindrance to the sale. But it'll be an extra assessment that no other home in this township has placed upon it. So that's a marketing decision. But we think, I don't think, the developer thinks that this location, this township is desirable enough and this location is beautiful enough that shouldn't be an issue.
Thank you.
If I can answer.
If you can't answer it, we're in trouble.
Go ahead.
How does this tie into the NPC? I mean, normally what would happen is you put up the money, $21 million, township would hold it, make sure you did what you had to do, either by bond or by letter of credit or by escrow. How does the township ensure that when you do this, the money is put somewhere and it's finished? So the township, who is ultimately responsible under another statute to make sure that the improvements are there, knows that it's all done.
It's a good question, Skip. We don't see this as replacing the obligation for municipal security. The way it's originally being proposed right now is that under the MPC, the developer can start these improvements now without posting any security. The township just won't let them sell a lot, won't let them make any money on the job until they post financial security to make sure the rest of the improvements are installed. So one of the things I think Ken and staff and we talked about is whether the NID somehow can also serve, whether the proceeds of that bond can also serve a dual purpose of financial security. If it can't, separate financial security would be posted as required by the MPC.
I think we would have one issue if we did put the collector road in from Pottstown Pike to Phoenixville Pike, and that was not completed. Somebody could argue in the township that isn't living there that through street would have to be completed. So we have to work that through.
Yeah.
I mean, it's a workable, there are some things we have to work on. And the other thing I thought about was what would happen if you sold one of the pods and that builder finished, but the road, the collector road wasn't done, and then we ended up having to finish the collector road.
Well,
Are you not going to sell any of the pods until we're all done our improvements?
Well, as I said, I mean, under the first scenario, there'd be either the roads would be completed, or if they're not completed, by the time we sell a unit, the financial security for that improvement would have to be posted with West Goshen Township. So under the traditional scenario, it's no different than the traditional subdivision. If a developer could come in now, start doing work on this project, The township would not let any lots be sold, wouldn't even let the plan be recorded. I don't think you would, no, for lots. But we could come in and do it. And then when we're ready to sell a lot, we would have to come in, record the plan, and then post financial security for whatever improvements haven't been completed. So that would all stay in place. That mechanism would not be interfered with.
Okay.
Yeah, so in addition to that, because these are being sold to institutional buyers, as Ken had articulated.
Bonds, you mean?
The bonds, I'm sorry, thank you. Typically, the township will enter into what's called a development or construction and funding agreement with the developer, which articulates how those improvements must be completed in conjunction with the township standards. And in that, bond buyers typically want to see that there is a mechanism to ensure that the improvements in which they're buying bonds for is completed upfront as determined within that time period in which the IRS allows for draws on that trust estate that Ken mentioned be made. So the IRS provides that the project fund must be drawn upon within a 36-month period, and it's determined that the development agreement ensures that those improvements are completed, whether there's adequate funds or not. The developer typically agrees to that and is required in the development agreement. So that is something that the institutional buyers are required, and that's an added level of protection for you as the township.
That's all I have. I mean, my other comment would be, knowing, Lou, you and I have been involved in a few litigation aspects where people forget what their responsibility is when they move into a given community, whether it be a homeowners association or whether it be special assessments. So somehow this would have to be done in a way in the paperwork where when somebody walks into the settlement table, they're not just handed a small piece of paper. They have to understand what their costs are to move into this place. Because I can see a group of people here down the road and looking at the supervisor in West Goshen Township saying, how come I'm paying for that public road that everybody uses?
That doesn't happen, does it?
Never.
No, we did have that discussion.
No, and we can get into all these details when we get to the hearing part of it in a couple of months. But yeah, there has to be disclosure statements, and it has to be in the public offering statement. I'm sure it has to be in 15 different statements. But really, you'll probably have that anyway, no matter how many statements it's in. But we'll have to do the best we can. I think the people will know going in, because when they see that public offering statement to buy in this community, it's going to be a line item. Assessment, $2,000 or $1,800 per year, 30 years for park or for the road. So, but you're right, they'll forget that about a year after they bought the house.
Well, what they'll not remember is they thought the assessment was for their park.
That's true. Well, they'll have to handle that. It'll be your park by then. So that's it. We don't want to take any more of your time. And I know it's all new, but and you'll get your own counsel and seek your own bond counsel here. You have certainly capable counsel. Let us know if there's anything that comes up, if there's any questions you want answered, if there's anything we missed. It's an open door. We'll get you the information. Probably you'll hear again from us when the study is completed. And then Ken, your team will swing into action, and we'll start the mechanism for asking for a hearing on this so we can get it in place.
And what's that time frame look like for you? I mean, as far as the study being completed?
So pursuant to the statute, we have to prepare what's called the Neighborhood Improvement District Plan, which one allocates the special assessments, talks about the mechanism behind that so that it can formally be referred to over that 30-year period. We are in the process of drafting that. I would say within the next 30 days, we should have that document finalized.
Thank you.
I do think it's a very well thought out plan if the statute puts together and you're protected. Because I do think it gives you everything up front, which is very good for the citizens that are living in the township now. The other way, it's a phase that'll take forever.
Right, and speaking to other folks, they're saying they wish that construction was done this way, where you have these improvements put in first, then the houses come in afterwards, rather than what we've been seeing has been mentioned. You can have a situation where you just build the first 100 houses, you stop.
Well, I was first approached about it. I never heard of it, and I've been doing this for 30 plus 35 years.
It's new to us too.
And Lindsay and Ken tell me that there's communities, in Casey, you've seen down south in Maryland or other places.
Yeah, there's the one where they're going to look at Virginia.
I think you mentioned Gettysburg too. There might have been
Yeah, small.
Gettysburg, yes.
That was townhouses, I think.
On a golf course, yes.
Lou, there's a question from
Yes. No, just stay there.
Stay where-
Get the crowd.
We're creating a district within the zone by doing this, is that my understanding?
Creating a district within the township.
It has nothing to do with zoning at all. It's strictly a designated geographic area, not a zoning district, not an overlay, nothing to do with zoning.
Well, I just want to make sure that, you know, we make, just check to make sure we're not spot zoning or doing anything.
This has nothing to do with zoning. This isn't a zoning issue,
If we're
Tom.
creating, well, my concern is if we're creating this and other communities decide they want to do something, and, you know, something similar to that, but it's not allowed for.
It's really, it's a taxing district. It's a taxing district. It's not a zoning, it has nothing to do with land use law. It's the board saying for this geographic area, which in this case would be Greystone, you know, how many acres, about 400? For this 400 acres, that's going to be the special need district of West Goshen. If you buy a house in Greystone, you're going to be paying more for that. So I hear what you're saying, but and if anybody else wanted to do it, I think if anybody else wanted to, I can't see it in West Goshen because you don't have anything left. No, we really don't have any big projects left. But if anybody else wanted to do it in this township, I don't think it would, they'd have to come before the board and do what we're doing and see if you could create another taxing district.
Doesn't the borough have something?
Yeah. Westchester Borough has one. You know, they don't call it a NID, they call it BID.
Business Improvement District.
Where the businesses have all agreed in town to a special assessment, to pay a special assessment so they can do this stuff like the planners and the street cleaning and all the other stuff, cleaning the sidewalks that the borough ordinarily would do. The restaurant festival, all that. So that's a commercial example of it.
Is there any chance this district could be expanded to include surrounding communities, or is it going to be, are we guaranteed that it's only going to be Greystone and not Caswell or North Hill, or?
Well, it's really up to the community. It could be, have larger borders, but then everyone within the district would have to pay assessments. And so the idea is here that it's an upscale development and it won't be an insignificant assessment, and they are paying for them up front. And to expand it means that more people in the community would have to agree to assessments.
Doug, we would never create something outside of the borders. This is a brand new situation that would put additional costs on them. These are only held for costs within this development.
Yeah, there's one property owner involved in this project, and it's Mr. Jarakian in the back. That's it, no one else. And the reason that that would never happen is because there has to be a consent of those that live there to this assessment. The beauty of this is those people aren't around now, that, well, except for Dean and his family. Sorry, Dean. But but I think to do it on an established community would probably be a tough nut to crack.
Gentleman in the back, check your shirt.
Yeah, hi. Just want to understand the scenario, that hopefully will happen, but where 3 years from now this has been built out and there is a recession, there isn't the ability to sell, develop the property to the extent required, and the developer defaulted on their share of the bond payments. What rights do the bondholders have against the township at that point if they pass these improvements over to the township?
The township has no liability at all, nor would the county at the IDA. They're only liable to the extent of the IDA, assuming they issue the bonds, would be liable to the extent they receive revenues from the project to pay those. They would foreclose on the property, liquidate the real estate to pay the bondholders.
Does foreclosure mean denying access to the roads and the improvements?
It would just be the taxable properties that, for which they haven't received assessments, because all the improvements would have been ceded to the township, so they wouldn't be subject to foreclosure.
Thank you.
Are there any other questions?
I have a comment.
Okay, comment.
Having been chairman of the Chester County Industrial Development Authority for 9 or 10 years, I totally understand the concept We did this on a number of industrial projects, and it's very, very similar. It's put together the same way, where there's no liability coming backwards. So, thank you.
Thank you. Thanks for your time.
Thank you. See you. See you. I
don't see it here. Yes, Westchester Library Annual Presentation, Howard Sunwall.
Is anyone from the library here? Okay, let's move on.
Regulating trees in the row. This is ordinance number 7.
That's you, Skip.
Okay. This is an ordinance that was drafted in order to set up the requirements of removing of disease or dangerous trees from public streets and public right-of-ways, definitions of the trees and branches. If someone does not do it, the township can then so notify them to do it. If they don't take the trees or the dangerous trees or limbs out from the public right-of-way, then the township can do it and then assess the property for the work of cleaning up the problem. So we have ordinance here. We have, I think you've done this already, you continued it from from August 16th to tonight. B1 was the approved publication in the Daily Local News on August 8th. B2 was correspondence from our office to the law library providing the opposed amendment for public inspection. And B3 is correspondence from our office to the Daily Local News providing the same amendment for public inspection. Very simple ordinance, basically cleaning up the right-of-way if someone has trees overhanging it or in the right-of-way. That also includes things such as some type of shrubbery and bamboo. I was about to say that, bamboo definitions of that nature is when you look at the trees.
We've done this all along. We go into property owners, but now it's an ordinance form.
Yeah, with the bamboo.
Can I make a motion that we adopt the ordinance?
Do whatever you want.
Yeah, and sometimes in the back of the houses, there's bamboo. We got a lot of neighbors that have that.
We discussed this at length last meeting. We did not want to get in, the board decided not to get in our business.
And this does not speak to that at all. This is strictly some tree or some type of shrubbery that is in the right of way affecting people's use of the roads or affecting people's health and safety in the road system.
Because that's where I was wondering, rather than having weeds, bamboo, and dangerous trees, just eliminate bamboo.
Well, now we have bamboo in the right of way that damages our vehicles.
If it's in the front, then I can go.
Yeah, this is strictly
That's
right
where it
of
is, the back.
Strictly right of way. This isn't any rear yards. That could be a civil matter between two property owners if it's.
Yeah, hitting frozen bamboo is like hitting a rock.
Absolutely.
The current standalone ordinance with regards to bamboo, which is still in place, says that bamboo cannot be within 40 feet of an intersection.
Right.
So,
Yeah. I'll make a motion to adopt the ordinance.
Move in second.
I'm sorry, second. Chris?
Chris.
Okay.
Any questions?
Sorry, I'm a little slow.
Look like you're hurting.
Yeah, I had to carry a casket today, and my back's a little sore. The ordinance, although I do agree with, there are some problems with trees and overgrowth and stuff. What is the determination for height, setback, and so forth?
We've used 3 feet by 15. That's what we've used, but sometimes it's worse to put a specific number on it. But rule of thumb has always been 3 feet back, 15 feet up, because that gets our trucks and our mirrors and that type of stuff.
we constantly receive complaints from Craft Cross Company.
Yeah.
When school starts,
Yep, we get
the
a
police department's getting, and Dave's office is getting faxes, almost on a daily basis, from the school bus drivers complaining about stuff touching the side of their bus. So this will alleviate that.
Right, so it's 3 feet in from the curb.
That's what we've always used.
It's 15 feet high.
And obviously, if bamboo falls because of ice, then we have an instant issue with snow plowing. We send a notice about it.
Yeah.
Thank you.
Any other questions?
So, I mean, that's a good point. I mean, just for any future possible litigation, Skip, do you think that should be in the ordinance, some sort of parameters as far as how far back,
No.
how high?
I do not think so. I think the road crew can make that determination as to reasonableness. I mean, unless you're getting a lot of complaints with people walking in here or the township building if they do cut too much, but right now, that, in my opinion, even that 3 feet and 15 feet, you would have to take a look at. For instance, if there were wires up 20 feet and they were touching the wires, you may have them cut that before the utility company gets there if they're doing it. So I think you don't want to tie yourselves up.
And that's why we left the specifics out. We discussed it last time. That's why we left them out.
So it might be better to leave the specifics out.
Because there might be some cases where, you know, they gotta go higher.
Right, yeah. I just, just being an attorney too, you just.
No, I know, but the difficulty, it's really a case-by-case basis. If I'm at an intersection and I have to go 5 feet, maybe I have to go 5 feet for sight distance.
Yeah.
So it really,
Okay.
okay.
Go ahead.
Can I just have a follow-up question?
Do it from there.
Now that I'm thinking about this, because my property borders a state road, but I have trees that could come close to it, is this ordinance going to impact that as well?
Yes.
On a state road?
Yes.
All public roads.
All public roads.
The state's not going to maintain that road. They're going to expect the township to do that maintenance when it comes to sight distances and the public welfare.
Okay, all in favor?
Aye. You're on, Skip.
This is just,
We were requested.
Good.
We were requested to prepare an ordinance just for discussion purposes, not for adoption, because there's been no hearing on it yet, outlining, similar to what happened with the trees, adding provision in the township code prohibiting dumpsters and storage units upon the highway, streets, or roads within West Goshen Township. Again, in talking to you, there were complaints from people that people were storing dumpsters and storage units themselves in the highway and therefore blocking traffic or causing traffic hazards. So this precludes people from doing that. And obviously, there's a fine if you don't. If you do it and then you don't remove it within the time frames that the township requires.
Yeah, we currently have to, we don't have any enforcement mechanism on the staff side. We have to call the police out to instruct them to move it, so this gives us some flexibility.
What would the assessed fine be, Casey?
There is no assessed fine in this. It would be determined by the district.
It's assessed by the district court. We don't assess the fine.
There's usually a minimum to a maximum.
Right.
Okay.
Right.
Every time we've gone, Chris, they move.
Yeah, they move them
The
immediately,
dumpster
yeah.
companies understand,
Yeah.
you know, that, you know.
If there is an assessed fine, Chris, what would happen is probably the first time it would be very minimal. It would depend on how many violations there would be as to how it would go on.
We just want it out the street.
Yeah, sure. Yeah, street safety.
This all came about because a lady almost got hit.
Yeah.
She was riding a bicycle. There was a dumpster parked in the road, and the car saw it at the last minute, swerved, and she was on the other side of it and almost hit her. So she called me and was very upset.
Well, within that discussion is the all-terrain and dirt bikes that we had while we were there. So this would be two things, right? Skip,
Yes.
that would be,
Again, this is a discussion if you want to schedule the appropriate hearings to pass this as well. Basically, it's a definition that outlines all-terrain vehicles, what an ATV is, what a dirt bike is, the manner of operation within the township, and anybody who has the right or equitable title to the property in which the ATV or dirt bike is being operated. It outlines limitations as to where you can do it. Obviously, you can do it on people's property. You have to have it licensed if you have it on the street. It also talks about the operation in properties and the size of the properties. It has to be at least a 1 acre tract of land in order to have an ATV operating on it. So I guess if you have a half acre or a quarter acre of land, you're noisy to the neighbors because of the muffler systems. It does suggest some noise limitations to the mufflers, but obviously they're somewhat like they're noisy if they're in a small tract of land. So it does outline those requirements and then goes into penalties and violations that the police department is so authorized to issue appropriate summons and tickets if there's a problem.
Can I just make a statement, if possible? Is there?
You can make a motion. I'd like
Well,
to
advertise
make the
the
motion
intent.
first and then ask for the questions.
Absolutely.
Okay, I'd like to make a motion that we proceed with these two ordinances and refer them to the solicitor, advertise them, et cetera.
Yep, these are non-zoning, so we could adopt this at the October meeting scheduled.
That is correct, a non-zoning.
So we could.
They're just additions to the code.
Question.
Jay Atkins, Glen Avenue over in Glen Acres, and I want to thank the supervisors for taking this under advisement. Things have gotten worse, just saying, since it was brought up before, and this, I think, hopefully will remedy the situation. The only concern I would have is the classification of a dirt bike. When you read what they say, it could be interpreted by a certain individual saying, well, that's not a mini bike. And I don't know, maybe if the word mini bike would need to be specifically put in,
I'm not
or...
sure if there's, Kristen Camp researched.
Chris worked on that? Okay.
Dirt bike is the best definition we found.
Okay.
Mini bike.
It all fits in.
Dirt bikes, so.
Dirt bikes, mini bikes, okay. Yeah, because that's, no, okay. So, but yeah, that would definitely, because the situation's continued that after the police and the zoning, Bill came out and talked to him, it's continued Sundays, holidays. We now have, I purchased my own ANSI standards decibel meter, well over 65 all the time. So, again, I thank you, look forward to hearing some more next month.
Well, you're
Appreciate
welcome,
it.
and we'll have it on the agenda.
For adoption next month.
The other thing, we needed to also protect the landscapers and everybody else to make sure all trained.
Understood, yeah.
So they could do their
Definitely.
jobs and they could cut lawns and so that took a little bit of time on our end, and Kristen put all that in there. This is to protect, the safety.
Well, that and also the safety, like Chris was
Tranquility.
talking last time we discussed it, the safety issue alone on a small lot, want to lose control of that thing's off and through a fence and taking care of somebody.
All right.
Thank you very much.
We could, I'll talk to Kristen, but we could add, it could be, we could make a dirt bike and or mini bike as the
She
definition.
couldn't find anything for mini bike, it was just dirt bike.
Also known as
And put aliases and also
motorcycle.
Camper.
Yes.
Awesome. Thank you, gentlemen. Appreciate it.
Thank you.
Okay. Anything else?
Do we need a vote?
Yes.
Yeah.
we do. Call vote.
I made the motion.
Yep, second.
All in favor?
Aye.
Very good.
Next is resolution number 16, 2017, annual Kids Cancer Connection. Casey?
Yeah, this is our annual kind of feel-good resolution, number 16, 2017. The American Cancer Fund for Children and Kids Cancer Connection provide a variety of vital patient psychosocial services to children undergoing cancer treatment at Children's Hospital of Pennsylvania, Children's Hospital of Pittsburgh, as well as participating hospitals throughout the country, thereby enhancing the quality of life for these children and their families. The American Cancer Fund for Children and Kids Cancer Connection also sponsors Courageous Kid Recognition Awards, Family Sailing Programs, Pet Assisted Therapy, Community Get Well Cards, and hospital celebrations in honor of a child's determination and bravery to fight the battle against childhood cancer. We seek approval.
I'll move for approval of resolution 16.
Got a first and second. Any questions? Hearing none. All in favor?
Aye.
Yes, sir.
Resolution 17 of 2017 annual MMO for the three township pension plans. Stacy, you're on again.
Sure, this is the annual MMO for, oh yeah, I got back to 14, we're good. I'll read the whole thing, we do this once a year. Section 302 of the Municipal Pension Plan Funding Standard and Recovery Act of 1984, also known as Act 205, requires the Chief Administrative Officer of the Municipal Pension Plan to determine the financial requirements and minimum obligation of the municipality of the pension plan for the following plan year annually. Whereas Section 304 of Act 205 further requires the Chief Administrative Officer of each pension plan to submit certified financial requirements of the pension plan and the minimum obligation of the municipality with respect to the pension plan to the supervisors on or before the last business day in September annually. And whereas the actuary for the township's 3 pension plans has certified to the accuracy of the calculations in deriving the 2018 financial requirements and minimum municipal obligations and the calculations conformance with the applicable provisions of Chapter 3, Act 205. And whereas the township manager in his capacity as the chief administrative officer of the township's 3 pension plans has submitted certified 2018 financial requirements and 2018 minimum municipal obligations. So it's resolved that the Board of Supervisors hereby adopts the following 2018 financial requirements and 2018 minimum municipal obligations for the administrative and road employees pension plan financial requirements of $399,015 and minimum municipal obligation of the same number, $399.15, for the sewer employees pension plan financial requirements of $144,055 and minimum municipal obligation of $144,055, for the police pension plan financial requirements of $515,010 and a minimum municipal obligation of $307,836. So essentially this will go in the budget for 2018 for a minimum municipal obligation for next year.
Thank you. Good, I'll second it. Any questions for the audience? Okay, do the first and the second, all in favor?
Aye.
So, any other item? Oh, yes, Mark.
We have a hearing, so if anybody wants to stick around for that, I know they're not excited.
Cell tower hearing.
Cell tower. It's on a cell tower, I know.
What is the definition of a public meeting? And I'm asking, no, when the township places an ad in the Daily Local announcing a public meeting, what does that mean?
That the public is invited.
Okay, does, Mr.
Are you saying public hearing or public meeting?
Public meeting.
Okay, if the township places an ad that the public meeting is noticed to the residents or the public in general that they're having a meeting, and that meeting is conducted under the Sunshine Act, and it's in a given location at a given time.
Does that mean the elected officials are expected to be there?
Well, that's a loaded question in itself. The elected officials would be there. You would need a quorum in order to conduct business of the majority of the elected officials, but they're not required to be there if for some reason they have an emergency or they can't get there or there's some other issue. Doesn't mean there's no meeting at that point in time if 1 or 2 of the officials, if there's enough for a quorum, don't show up.
Well, I'm asking back to the MS4 permit application. That meeting was publicized as a public meeting. In June and July, the board meetings here, Mr. Lalonde and or Mr. Craig announced that we would have public meetings.
Yep.
But
A meeting open to the public.
when the residents showed up to that meeting, there weren't any elected officials there. And that, I thought that was a requirement of a public meeting. Because now back to, they never saw that plan.
That wasn't the intent of the meeting or the advertisement.
Okay, and I'm just, for facts, I'm not going to argue. So,
Well, there's let me just suggest something. There's 2 different ways of conducting a public meeting. Sometimes public meetings are advertised either on your website or, for that matter, posted on the door or somewhere to get input or to let people know what is going on. no decisions are made at that point in time. It's not a sunshine meeting. And sometimes they can have those meetings without the public comment. They just do it because they think it's the right thing to do. The second way of a public meeting would be an advertised meeting to conduct business that's required by the elected officials, like tonight. And they would be here under an agenda, and they would conduct their official business under the Sunshine Act in front of the public.
Right.
But we could have a public meeting a week from now where the solicitor, the township engineer, Casey, and bond counsel came in, but we wanted people to know what we were talking about if the township was thinking about doing something like that that would require those people to get together and meet. You don't necessarily need one of the supervisors there.
Okay.
Or
So when it's announced that, we're having this public meeting to present this plan and public comments will, be accepted, does that mean comments that any residents made who were never heard or considered by the supervisors?
They didn't conduct the meeting, so no. And we recorded that meeting. I did minutes. Those are posted. The meeting's posted on our website. But it wasn't a board meeting. There was no intention ever as a board meeting.
So
I'm not sure what the question is.
there were some
I
really,
guess the question is, do you people know that there was a meeting, and were you given the input from the residents when the meeting took place? That's the question.
did we know that there was a meeting?
And secondly, any comments that the residents had, were they reported to you?
I did receive comments from Margie and from some other folks. I did not attend the meeting. I had another obligation. I did get the presentation.
I also
I personally can only speak for myself.
okay. Again, it just concerns me because going back and watching the tape from June and July, when it was presented to the public that was here, it was clear that it was a public meeting. However, if you look at the minutes from June and July, the minutes state that it was announced that it was going to be a staff meeting with HRG, the engineers, open to the public. Well,
And that's DEP's language that we had to have a public meeting.
okay. All right, I just wanted to get that out there. And then also I did send an email requesting amendments from those June meetings, minutes, and I'm wondering where the board stands on my request.
I don't have
You didn't send anything. What did you send? When did you send those? The last email I had from you was Tuesday morning, say you were going to send something. I never got anything else.
No, there seems to be a problem when I send email or...
That's where we've been waiting. I immediately forwarded
The
you
answer
to
is,
the board, and we've never.
I don't have anything from you, and I really get all your emails, so I did not receive anything pertaining to the minutes.
I have not had a problem receiving any of your emails. It comes through Gmail.
Nothing.
I've never had a problem. I
Okay.
never got any, and you didn't answer my email saying I will gladly forward those comments to the board. I never got anything.
Did you get that?
Did you get my response saying that the agenda was posted?
No, I'm referring back, I sent an email about 2 weeks ago.
Oh.
I was very upset that I was
Oh,
misrepresented.
yeah, the
in
one you
June
asked for an
minutes.
apology, or
Yes,
an apology?
yeah, that one.
I was a little confused on that one.
Well, the minutes stated that I said that I thought the residents should be refunded the entire balance of the general fund. I mean, something that was so absurd that I think it made me feel like there was an attempt to make me look like I was a lunatic. And I would
think
like
you
those
used those
minutes
words.
You used those
in
words.
the email. I did.
Yeah, I think you did.
Yeah.
Called yourself a lunatic.
So where does the board stand on amending those meeting minutes? Because they're totally, completely inaccurate.
The board approved those minutes over 2 months ago. If you
Yeah,
want to amend, that's allowed to amend them. That's up to you.
I guess the only thing I could suggest is, look at the tape, and if what you're saying is clearly true, that you didn't say something like that, I personally don't have a problem going back and amending those minutes.
So look at the tape.
It's one of the reasons why we have the tape here.
Right.
So.
One of the.
Well, and that's one of the reasons I don't look at the minutes and read them, because I thought, well, we have the videotape now, certainly
Which is
there's
not,
not a problem.
which is not an official copy of the meeting minutes. You understand that?
Right, I do,
And we do not do verbatim, as Kristen Camp has repeatedly said, we do not do verbatim minutes. We'd have to have
I know.
Mr. Court's reporter
at an exorbitant cost, record the meeting minutes every time. We're not doing that, unless the board so deems fit.
Well, I did get that email,
Yeah, that
you
was
were
2 weeks ago.
upset.
Sure.
I couldn't
was
figure it
very
out,
upset.
because I didn't think what you were talking about was anything very, very bad. But I hope that,
Well, I
well,
thought.
we could go back and look at it.
Okay, and then you, also I had requested, what steps need to be taken when a citizen wants something on the agenda, a topic on the agenda? What steps need to be followed?
Send a request in?
Yes.
Okay, I sent a request in about 2 weeks ago requesting that an agenda item be added to tonight's meeting.
Yeah, if I remember right, it was the last couple meetings you've asked about citizens budgetary group, and we said no both times, and so we didn't put it on the agenda. You just ask right now again if you want.
I believe the minutes stated again a couple months, well, it was right after in June when you said, Margie Swart said that the citizens should get all the money refunded from the general fund, and then you followed it up with, I requested that a citizens finance a budget.
I don't think
but
that I said anything like that to you.
All right, it said that the minutes said that the board said it would take it under advisement. Again, that wasn't what was said, but where do we stand on having citizens attend?
You send
and
the
be
request
part-
in, and if the board wishes it to be on the agenda, we'll put it on the agenda. If we don't put it on the agenda. You can bring it up at any time.
Does the board ever intend on having citizen involvement in the budgetary process in West Goshen Township?
We do every workshop.
October 11th, October 18th, our November meeting, our December meeting.
But it's already developed then. I mean, you're basically
That's
saying,
why
here
we're
it is.
elected.
Ms. Schwartz, we just met today with our first round of department heads. We just saw the department head's raw budget request today. We have to have time to process it as a staff and then forward it to the board. I don't know how getting citizens involved today, where we haven't even reviewed the department head's request, is helpful at all.
And that's
we
why
have
we
public
started the
meetings.
open workshops.
Right, absolutely.
Okay, thank you very
Thank
much.
you.
Margie, I did find your email, September 1st.
Yeah, that's what I got.
Yeah.
So I think you didn't get you on there though, but
Yes, just has to exclude you.
yeah, but I do see the email, so.
So again, why was it denied? I simply asked for an agenda item for the, but this was, I'm not
Oh,
sure
I'm
if that's
talking about the email
yeah.
about your
But
statement.
again, when I wrote in and just a simple request, I request a citizen, or an agenda item be added to tonight's agenda, just for the discussion of creating a citizens finance or a budget committee. And the response, well, I'll let Mr. Lalonde say what the response was. I mean, it's a
You
simple
sent it to the
request.
board, there was no response at all.
No, you said, no, we will not do that. You said I was,
Oh, yeah, that's true. No, after I consulted with the chairman.
Yeah, that wasn't on September 1st. That's when you
No,
wanted.
I'm sorry for any confusion. I'm talking about your email regarding the statements you said you did not make.
Right.
I've been searching for them and I found it while you were talking about this subsequent
and
matter.
did you find the one that I just simply asked that a budget item be on the agenda tonight, just discussing a budgetary or citizen finance budget committee?
I did see that, but I defer to the township manager depending on what we have scheduled, what the time is, and so I didn't follow up on
Or
that.
the importance, maybe? Maybe allowing citizens to be involved in the budget process?
We will, at the workshops, we will.
All right, thank you very much.
Anything else for the good?
We do have a hearing though, if anybody wants to stay.
Cell towers. Very
I'll move for adjournment.
Okay.
Okay, you got it?